Yes.
Yeah, the lordship, the bench number two not sitting this court is fixed. I have some urgent motion lordship, I have to move it.
Urgent motion.
There are two lordship. I have already filed lordship is numbered and everything lordship. Very urgent. I'm grateful. Lordship.
May I please, Lordship, I would like to mention for listing on a criminal petition on 17 December, Lordship.
Why?
There is some urgency.
17 December not possible.
Lordship, the
Criminal? What criminal petition?
for criminal petition.
Huh?
Yes.
Not before this bench.
May I please, your lordship?
Yes.
I beg to mention item number 33, lordship.
33.
Okay, lordship,
33.
33. Any day after vacation, lordship.
On the prayer of MS
J. Chetri.
J. Chetri, Land Council for the petition release this matter after 4 weeks.
May I please, your lordship? With the consent of other side, I beg to mention item number 39 and 40.
39 and 40.
Okay, my lord, here one record was called for. My lord, that has not been received, my lord, that I will get it by tomorrow, my lord. May I pray, my lord, this matter may be taken up on Monday or Tuesday, my lord.
No, what is the matter?
Matter regarding my lord, appointment of a principal, my lord, in school.
Hmm.
So, my lord, they are said,
Next week, though, it's not possible.
my lord, any day next week, my lord.
Next week, it's not possible. After,
My lord, because otherwise that whole process is being stalled, my lord. That's why the court has called for the record, my lord.
So-
Only perusal of the record, my lord.
huh?
Only for perusal of the record, my lord.
Then nothing has to be done.
My lord, because otherwise whole process is stalled, my lord.
See, we'll have to peruse
Yes, my lord.
and decide and pass the order.
My lord.
If it's only for perusal, no issue.
My lord, otherwise.
What do you
because
mean by perusal?
I have taken the time.
For
of
you, it's okay, but we'll have to write
my
the
lord, because this is their petitioners also, they are also affected person, my lord, but they are supposed to be present here.
You are
They not
for?
here. I am for the respondent, my lord.
What respondent?
My lord,
Private
NCU's
respondent.
No, my lord, I am NC Hills Autonomous Council Education.
Hmm.
Lord.
Next week, it's not possible.
Any day, lordship. Any day.
After that, after next week.
After next week, my lord, the vacation will start, but we have.
Then, that's what I'm saying. Otherwise, all listed for orders.
Yes, my lord. For orders only, my lord, next week, my lord.
IA is for what?
I am, my lord, because my lord, in that petition, they are saying that, my lord, one interim order has been passed, but I have checked the reflection, my lord, order sheet. There was no order for interim, so they are trying to bring it
Let
up.
us see.
Yes, my lord. At
Next
30.
week. Just say next week.
Next week. Any day, next.
On the prayer of Mr.
R.R. Kaushik, my lord.
R.R. Kaushik, learned. What is your what is your
My lord, Northeast Hills Autonomous Council.
standing council?
Yes, my lord.
NC Hills.
Education Department.
NCHAC. Huh? This better after a week.
Next week. 17. My lord, deeply obliged.
May I please, your Lordship? Lordship, I beg to mention item number 11 and 12, Lordship. I have taken consent from the other side, Lordship.
Hmm.
Lordship, we have some difficulties today, and Lordship, there is interim, Lordship. That's
Huh?
why there is an interim, Lordship, in this matter, and we have some difficulties today, Lordship.
On the prayer of Mr.
Lordship, J. Abbas, Lordship.
Yeah, Land Council for the petition. List
Lordship.
this matter after 4 weeks.
Not, Lordship, not for it, because the state has some urgency, because there is some interim, Lordship, for which he could not join the service, Lordship.
3 weeks.
Lordship, only
3 weeks.
any date, Lordship.
3 weeks.
Lordship. Interim is there, Lordship, in this board.
Interim order passed the lesson.
Yes, madam.
May it please your lordship. Lordship,
Yes.
we had circulated an adjournment slip with regard to item 20 yesterday.
Yes,
What
on
was
the
the-
prayer of so and so, Land Council for the petitioner, list
Please.
this matter after 3 weeks. 3 weeks.
Deeply obliged, your lordship.
May I please, your lordship? Lordship, I beg to mention item number 11 of put number 9, lordship.
Yes,
My lord, this matter may be taken up on Monday, lordship.
Monday.
Yes, lord.
Yes. Monday.
Obliged.
May it please, my lord.
My-
My lord, I'm mentioning item number,
Next week. You just say next week. Hmm.
item number 3 of today's causes, my lord.
Yes.
My lord, an affidavit has been filed in this case by the private respondent number 7, my lord.
Hmm.
However, the same is not reflected in the record nor
3, item 3.
item 3, my
Item
lord.
3 is with item 4.
Yes, my lord.
Item 3 is with item 4.
My lord, the advocate is there, my lord.
Yes.
I have also informed him.
My friend says that he filed an affidavit. I received a copy, but that is not in record. So let it be on record and I think.
Okay, Mr.
R Thadani, my lord.
Huh?
R Thadani, my lord.
R.
Thadani.
Tadani.
Adani.
Thadani, learned counsel for the respondent number 7 submits that he has
Continue.
filed the affidavit in opposition. This, however, is not, the same is not take with the record. In view of above, this matter, the registry is to verify. This list, as prayed for, let this matter be listed after 3 weeks. 3 and 4.
No, my lord, not 3 weeks. He's already filed. It's not in record.
Okay, 3 to 8.
My lord, immediately after vacation.
3 weeks. 3 to 8. 3 to 8.
My lord, would your lordship be pleased to give?
Mr. J. Abedin so and so, learned counsel to
For
the
the
petition
petitioner in all the.
is present, huh?
But would your lordship be pleased to give a date immediately after vacation, my lord?
We'll see. After vacation, there are again more, so many vacations. Long vacation. Bihu vacation. We'll see after 3 weeks. All right. Yes,
May I please, your lordship?
yes.
Lordship, regarding item number 29, your lordship, lordship may be merciful enough to let me withdraw my wakalatnama.
Why?
This case, your lordship, I have filed the affidavit for withdrawal, and your lordship, I have served them with the notice, and the receipt is in the affidavit, your honor.
So we'll see.
Oh, your lordship. Lordship, the problem is my dog has bitten someone, so kindly book today, your lordship, because
We'll adjourn it, we'll see. On the prayer of Mr. MS.
feed us, your
Feed
lordship.
us. On the ground that her pet dog,
Yes,
pet
yes, lordship.
has unfortunately bitten someone. Therefore, she has to leave urgently to attend the
Notification of-
incident. And as such, praise for listing of the matter after 4 weeks.
Yes, sir. Obliged, your lordship.
Be careful.
Yes, yes, your lordship.
May I
It's
please, your lordship?
dangerous.
Lordship, item number 21.
Yes.
And lordship, 24, my lord.
21,
And 24.
1 by 1, sir.
Item 21, I'm on behalf of AK Purkas, so he's not feeling well, so I.
Huh?
He's
AK
Mr.
Purkasta.
Purkas is there. So I'm not, he's not feeling well, so.
2014 matter, what's this?
Well, for, we have to complete it, but for this
Huh?
physical illness, unable to appear. Lord.
I understand, but 2014 matter.
Maybe next week, lordship, because we can do it.
Are you sure?
Yes, lord.
Are you sure? Next week,
Next week, lord. Well, this time, fine.
Mr.
I'm MK Majumdar for AK
M.K. Majumdar, Learned Counsel, appearing on behalf of Mr. A.K. Purkasto, Learned Counsel for the petitioner, submits that Mr. Purkasto, who is leading in this matter, is unwell, therefore prays for listing of the matter on some other day. Considering that Mr. Lucasto is not unwell, reported to be unwell, list this matter after 4 weeks. However, considering that the matter is pending since 2014, the prayer for adjournment is granted as a last chance. 4 weeks.
And item
Item 24 is 2016, huh? You just said
Item
pending
24.
since 2016, yes.
Item 24.
Yes, your
Obliged.
lordship.
This is 24 is
21 or
2016, huh? Pending since, yes.
May I please, your lordship, with the concern from the other side, lordship, I beg to mention item number 25.
25.
Yes, lordship.
This is also 2016,
Yes, lordship.
yes.
My senior is not well, so lordship may take up.
Who is not well?
Lordship.
Who?
My senior MP Sharma on behalf of MP Sharma.
MS so-and-so. Why Yoshi? Your name, why Yoshi?
MP Sharma.
Your name,
HK Sumi.
learned counsel so and so submits that Mr. MP Sharma, who is leading in this case, is not well, therefore press the listing of the matter after 4 weeks. Praise the Lord. However, considering that the matter is pending since 2016, adjournment, a prayer for adjournment is granted as a last chance.
Yes, Lordship.
Should I back to mention item 23, Your Lordship.
20?
23.
23.
Learned counsel for the petitioner is unwell, Your Lordship.
Unwell. Who is unwell?
And Mr. M.S. Majumdar, Your Lordship.
AMS Majumdar, Since 2015, same order.
Your Lordship, it is for urgent listing. The petitioner is severely unwell. So, Your Lordship, if you could list it for urgent.
What is the matter?
It pertains to suspension of service, and the petitioner is deprived of his pension, and he's struggling for his medical expenses as well. He's severely ill, Your Lordship.
What do you want? When do we want?
Urgent listing,
When?
16/12,
Not possible. After 2 weeks.
after 2 weeks.
Ah.
Any other day, Your Lordship?
2 weeks, after 2 weeks.
Much obliged to you.
May please your lordship, my lord, in this case, my lord, D. Saikia, senior advocate who is leading the case, he is on leg in court number 1. This matter may kindly take up after some time, your lordship, pass over for time being.
What is the issue?
My lord, regularization of the ONC employees, my lord.
ONGC will will admit and list it for hearing.
My lord,
Will admit and list it for hearing.
people are at the verge of retirement.
It's okay. Next year we'll hear. Next year in the sense January. January.
My lord.
All right.
My
Heard,
lord.
Mr.
SS Goswami.
SS Goswami, learned counsel for the petitioners.
Yes, my lord.
This is an association, a petitioner. And Mr. N.S. Singh,
For all
Learned-
respondents.
learned counsel for the
One.
respondents.
Uh,
Admit list for hearing in the month of January.
obliged.
Matter is pertaining to regularization of the petitioner as grade 4 employee. Also pleadings are complete, Your Lordship. He is taking up the matter.
For disposal.
Lordship, otherwise.
Yes.
pleadings-
Are you ready?
Yes, my lord. My lord, in this case, my lord, respondent 5 was, my lord, appointed and, my lord, terminated from service. Withdraw the appointment right due to, my lord, interim order. So matter is urgent, my lord. So maybe take
Will
it.
admit list for hearing.
My lord,
Heard MS so and so, learned counsel for the petitioner. And Mr.
SKC now for private.
SK for respond, no, so and so. One,
Lord.
Number 4 for which,
Due Pamanya.
My lord, may I pray, my
Learned distinct counsel, so and so, and all record, for so and so,
my lord, matter is some urgent, my lord, because
Yeah.
petitioner is out from service, my lord, after appointment, my lord. So
Will admit list for hearing in the month of January.
date may be fixed, my lord, kindly.
It's okay, we'll see.
Much obliged, Lordship.
Lordship, Your Lordship, we have received Lordship, actually the hard copy of the entire record was misplaced, Lordship. Subsequently, we have filed an FIR, but Lordship, I have been informed that the E-file has been received and now it's in the process to reconvert it from E-file to Lordship, the hard copies. And so accordingly, Lordship, I am seeking Lordship for 2 weeks' time so that Lordship, I can have the hard copy and they can give me the parawise comments to file a detailed affidavit in opposition. Already I have filed an affidavit, Lordship.
Huh?
Already I have filed an affidavit to that effect, but a detailed parawise affidavit, Lordship, I need to file.
What affidavit you have filed?
Lordship, the affidavit states that, Lordship, the record pertaining to the petitioner has been misplaced, Lordship, and a committee has been constituted for finding out the same. But
So-
so subsequently, they have given us the report that the hard copy is not there, and we have filed an FIR to that effect. But Lordship, the e-file, Lordship, has been recovered, Lordship. So Lordship, they are now converting it back to the Lordship, the hard copies, Lordship. The hard
Wha-
copy. So
Hard
that
copy for what?
hard copy to
For
place
what?
it, to place it before the court, and Lordship to submit parawise comments, Lordship, so that we can file a detailed affidavit.
Heard MS so and so learned concept for the petitioner. Mr. D. Upamani, reiterating his submission made on 19/11/2025. Submits that. The records has been recovered and is under process of converting it to hard copy. Which, for which he pressed for 2 weeks' time to file affidavit. Had not been objected to by learned counsel petitioner. Let this matter be listed after 2 weeks. In the meantime, this D Upamani to Upamani learned standing counsel to file affidavit.
Lordship, fix the date, Lordship.
After 2 weeks, we'll see.
Obliged.
2 weeks, after 2 weeks, it's so many matters have been fixed. We'll see. Let them file.
He is not getting his pensionary benefit.
I understand. We'll see.
Benefits.
Yes, I understand. Every cases are that only, relates to that only. All right. we'll see.
Obliged, Lordship.
Matter relates to the pension of the petitioner, kindly look to peruse the last order of the.
Yes.
11/11.
Hmm.
They are directed to the respondent to.
record available now.
Petitioner retired in the year 2020, but till date, pension has not been released, as well as area salary also not released. Nothing has been paid to the petitioner since last 2020.
This matter, Lordship, I have received the instruction, Lordship. Dada. In the affidavit, Lordship, filed by the Deputy Commissioner, Lordship, they have stated that, Lordship, the file is with us, Lordship, with the CJM, Lordship.
Huh?
But we have received the instruction, Lordship, may kindly peruse annexure 2 of my instruction, Lordship.
Annexure to,
Annexure 2, Lordship.
hmm,
They stated that, Lordship, the file is with us, Lordship,
hmm.
but we don't have the file, Lordship. Even in the year 2020 also, Lordship, we have wrote a letter to the Deputy Commissioner, Lordship, that no official record is available with us, Lordship.
Have you seen the last order?
Lordship.
Huh?
On last occasion, Lordship, we are directed to obtain instruction, Lordship, from the Deputy Commissioner.
Hmm.
Accordingly, we have made a communication, but we are yet to receive the updated instruction, Lordship, in this matter.
Last occasion, Lordship, Honorable Court directed to the Standing Council of the High Court, Lordship, to obtain instruction from the CJM, Lordship, of law. Deputy Commissioner, Lordship, Deputy Commissioner filed the affidavit in opposition in this case, Lordship. This is page 47 of the affidavit in opposition filed by the Deputy Commissioner.
Yes.
Lordship, instruction is, we don't, Lordship, may kindly peruse the annexure 2, Lordship, of my instruction, Lordship.
No, I've seen it.
Yes.
What you are saying?
The affidavit, Lordship.
They
Deputy
stated
Commissioner-
that, Lordship, the file is with us, Lordship, in the office of the CJM, Lordship, but no official record is available in the CJM, Lordship.
On last occasion, the matter was heard, Lordship, and I was asked to obtain instruction, Lordship. This is awaited. Lordship may fix it on next week, Lordship, in the meantime.
many occasions they have taken time, Lordship.
Lordship, what will happen without instruction?
Higher and there.
Then Lordship may pass any order, Lordship.
Deputy
He is
Commissioner,
so insisting on the
since
Lordship.
2020, he is nothing, Lordship, he has paid to petitioner paid. He is a retired person, Lordship. How will it survive, Lordship? Since 2020.
Just
he has
wait.
Only pays for debt, Lordship.
See, they have written a letter to the district commissioner. Have you shared it?
Yes,
Lordship.
In the affidavit, Lordship, Deputy Commissioner stated that there no document available with us, document available with the CGM. Now CGM came that we have no document available.
Ah.
In the year 2020 petition.
Heard Mr. ABT Hawk,
Yes, Lordship.
learned counsel for the petitioner.
2020 is not saying anything.
In terms of the order dated 11/11/2025, the learned Chief Judicial Magistrate Dima Hasso, Haplong, has communicated to the District Commissioner Dima Hasso Haplong to provide documents or details of any letter issued to the issued to the official issued to the office of the CGM Dima Hasso Haplong in connection with the forwarding of service book or any other papers pertaining to the employment of the petitioner, which Mr. So-and-so learned counsel for the. You are for?
The Deputy Commissioner, Lordship.
Lordship, I am for the Guwahati. Please, on behalf of HK.
Appearing on Mr. appearing on so-and-so on behalf of SK Das, Standing Council, Guwahati High Court. Submit statement. The Chief Judicial Magistrate Haplong is still is yet to receive the response from the District Commissioner Dima Hasso, Haplong. In way above, MS M. Bhattacharya learned State Council to obtain instruction list after 2 weeks.
It may be big regarding pension, procedurial salary.
Every other cases are pension matter.
Nothing has been paying.
I'm telling you, every other pension matters are, every other cases are pertains to pension. We'll consider. All right. I understand.
Obliged, your Lord.
Lordship, here I am seeking for some time to file my affidavit in opposition.
Last of it, they took time, Lordship. Lordship may
Ah.
grant some time to file affidavit.
Immediately after the vacation, Lordship.
Heard Mr.
A Decca, Lord.
A. Decathlon counsel for the petitioner. On the prayer of Mr. D. Upamani, London Technical Higher Education Department. Further, through 3 weeks time is granted to file affidavit.
If it is not inconvenient after 3 weeks, that may be fixed. Any date, Lord.
Let them file, it's no
Then we have
use.
to again mention, Lordship.
Huh?
Again, we have to mention for listing. Matter is not automatically listed, Lordship.
It will be listed, it will be, once it is filed.
I'm for responsibility.
So after
Ah.
3 weeks, any date, Lordship.
I'm for responsibility. Yes.
Ah,
AG.
ah.
Obliged.
One name will.
Give it in the month of February.
Yes, yes. First week of February, Lord. First week of February.
Just give me the responsibility.
Yes. Diplomat. Obliged.
These two cases, whether the counsel for the respondent, my lord, he is having some inconvenience, my lord, as though he has not informed. But my lord, there is another counsel for the department, my lord. Lordship may arrange the other counsel, my lord, to appear in the next step, my lord.
Why?
Because, my lord, because of their absence, my lord, this matter is not being adjudicated. Relates to promotion, my lord, the bestmates are promoted. The DPC, though the posts are lying vacant, they are working in on inches basis. Though to the region, they have not been promoted.
What is the requirement? Qualifying years?
Qualifying years is, my lord, 10 years.
Huh?
The rule says that 10 years is required for, my lord, from the.
Huh?
I have annexed the rule also, my lord.
Yes.
Lordship is taking up, my lord,
Why your matter, why your case has not been considered?
without any region, my lord. They have not assigned any region. They have not filed any affidavit.
They say, you have said so here. The another diffuser held on 20 on, and it has been informed that case of the petitioner have been rejected on the ground that he has not completed 3 years service in the cadre of District Fishery Development Officer.
My lord.
Hmm?
My lord, Lordship is taking up the Tirthanath Hazarika matter, my lord.
Huh?
2653. my lord.
Tirthanath Hazarika.
Yes,
Huh?
yes, my lord. I have annexed the rule at page, my lord, 31.
Page 31, yes.
My lord.
Where is the promissory fees? Relevant?
Relevant is, my lord, pay 52,
52.
my lord, 33, Lordship will find. The post is
Page.
page 33, my lord.
Hmm.
Rule 52 says that the post of joint director is, my lord, promotional post,
Joint Director?
joint director.
You are seeking for Deputy Director?
Deputy director, joint director, same, my lord. I am seeking for deputy director.
Hmm.
The post of deputy director is, my lord, promotional post on the basis of seniority cum merit,
Ah.
my lord.
So which post you are seeking promotion?
Correct.
Then you come to, where is this Deputy Director?
Page 35, my lord, rule 11B.
35.
Yes, my lord.
For promotion in the post cadre of Deputy Director shall have to render service in the cadre of the second. Minimum period of 3 years
3 years,
or 12 years.
continuous service,
As a DFDO, 3 years.
3 years.
Have you complete 3 years?
No, the other condition was will find or with 12 years of continuous service experience in different cadre.
Different cadres means what? Amranga district, this is what? DFDO lecturer. District fisheries. Were you in the other cadre?
Yes, my lord. Other cadre means, my lord,
Sorry. This Deputy Director, the feeder post can be DFDO,
yes, my lord.
lecturer, regional fishery, this thing, Amranga or district fishery development or special officer planning or superintendent of fisheries training, or these are the other cadres, not the DFDO. Therefore, at least for a minimum, or fisheries information officer, at least for a minimum 3 years or with 12 years of continuous service experience in different cadres of so and so. Were you recruited directly as a DFDO?
No, my lord.
Huh?
My recruitment was fine. I was recruited as my lord, as the FDO.
Ah,
Page 9 is the appointment order, my lord.
then
Thereafter, my lord, I was promoted as DFDO on 3/31/2023.
is there any DFDO? FDO?
My lord.
Huh?
Fisheries Development Officer, my lord.
See, this is very clear. These are the DFDO and other grades, other officers who can be promoted. In that case, if for DFDO, one must render 3 years, right? For others, who can be promoted,
My lord, the other,
others are
my lord,
Amranga or DFDO or special officer planning or superintendent of fisheries or marketing officer or fisheries information officer. They have to render.
yes, my lord.
You have not rendered all this post which is mentioned here. Where is the rejection order? I mean DPC, DPC minutes.
They have not rejected, my lord.
They have said, you have said so here.
Hearsay, my lord, that is hearsay, but they have not passed any order.
So what do you have to say then?
They-
Was there any DPC?
Yes, my lord, the two DPCs are held,
So would like to see the DPC minutes.
my lord. But I mean, call for
But
the-
if you have not rendered 3 years, you are not eligible.
That is what, my lord, I was praying for. my
I
lord,
mean, even if you have complete 3 years, you don't have right to be promoted. At best, you may have, if there is a post, you may be right to consider. That's all.
my lord, Rosmi, direct the authority, my lord, to place the DPC minutes. my
No,
lord.
no. Unless you can show that you have not rendered any other post which has been given in the Rule 11B.
In these cadres, my lord, 3 years or 12 years of continuous service experience in different cadres. I have got the 12 years of service in different cadre, but as DFDO, my lord, I have not got that. 3 years of service.
Then
So, my lord, if I have, my lord, fulfilled the other conditions, that is 12 years,
it's not that. There are other officers. Is there any, see, either from the DFDO or other officers? You are not other officers, you are admittedly a DFDO.
no, my lord, it is.
Or a DFDO,
The rule says that the other officers mentioned in the Rule 11B is the ballot of DFDO and equivalent cadre. That is for 3 years. In the equivalent cadre, they have to render 3 years of service, or they have to render 12 years of continuous service.
You saw that these posts mentioned in the Rule 11B is equivalent to DFDO. Let us see that.
But may I read again, my lord, 11B.
Yes, where is the post? You said these are equivalent posts with DFDO. If they are equivalent with the DFDO, how they will be required 12 years?
They do not require 12 years. They require 3 years. They require 3 years of continuous service. In other cadre, in lower cadres, they will, if they are not working as DFDO, the other persons who the other service will be counted. That is 12 years of continuous service. They have counted in other cases, my lord. They have already promoted some persons who have not completed 3 years of service as DFDO. I have annexed that orders, my lord.
Let us see where is this. Yes, who is appearing for the fishery department? Anybody?
P. Sharma is having some medical difficulty. Lord, so direct the other counsel to appear in this case, my lord. There is
Whom
another
we should
counsel.
direct? And Mr. counsel for the petitioner. But prime facie, I'm of the view that these are
I
not,
try to satisfy, my lord.
otherwise why these are obviously a lower grade post which which is mentioned here. Therefore, it requires 12 years. For DF, 3 years. So you
Not
cannot
yet
have,
this year.
you cannot have the cake and eat it too, right? Though heart may, I mean, laddu, you cannot have this laddus in 2 hands.
My lord, they have made
Uh,
the rule like that.
It
also.
is informed by Mr. Isaac Land Counsel for the petitioner that Mr. P. Sharma,
My lord.
Land Standing Council Fishery is not unwell, is unwell. Christoph, in view of above, let the other standing council or the government lawyer
Has to clear, my lord.
be,
Has to clear.
will not say, let the other standing council of the department, fishery department, to appear and file to file the affidavit. List after 4 weeks.
Direct the, my lord, counsel to produce the
Let them
special
file,
notice.
let the council come first. Yes.
May it please your lordship.
Yes.
In this matter, my lord, affidavit is yet to be filed. My lord, on 25/9/2025, my lord, an interim order was allowed. And then, my lord, due to certain typographical mistake in the cost title, my lord, we filed an IA. On the last occasion, the IA was allowed, then we were allowed to, my lord, rectify the, my lord, corrections, my lord. But inadvertently, my lord, the interim could not be extended, my lord. That is why, my lord, I pray that interim may be extended. And, my lord, the respondent side will file their affidavit.
What is the matter?
My lord, the matter is with regard to, my lord, promotion, my lord. My lordship, if my lordship kindly peruse the order dated 25/9/2025,
Affidavit has not been filed.
not filed.
Heard, Mr.
MK Das.
M.K. Das, Land Council for the petition. Who is appearing?
The PWD Standing Council is there, but they will file. I am for the state respondents.
Mr. T.C. Chutia, Land State Council and the Land Standing Council for PWD are granted 3 weeks time to file affidavit. Interim order passed on
25/9.
25/9/2025 shall continue.
Should be, the response from the other side has not been filed, lordship.
My lord, I am from the Berlin University, my lord. For 5, 6, and 7, my lord, some time is required to file our affidavit.
And Mr. Swenso, Land Council. for the petition. You have filed the affidavit?
No, we also.
Who has filed the affidavit?
Lordship, none of them have.
None of them.
Okay. On the prayer of Mr.
VK Borwa, my lord.
and Mr.
MK Das. Lordship.
M.K. Das, Land Standing Council for BTC.
And
You are-
Berlin University, my lord.
Huh?
Berlin University.
Berlin University and BTC.
BTC.
On the prayer, I said, this matter after 4 weeks, so as to enable them to file their respective affidavits.
Highly obliged, lordship.
No, let us finish this first. 38, 13. No. Complete the supplementary. Once we take up the hearing, it's the period. Yes,
As per office not dated 10/12, nor ID card, nor unsecured,
take a fresh steps. Huh?
Can wait. We have already taken step.
When? When did you take the step?
To 12,
Hmm?
on to 12,
Huh?
on to, second
Okay.
December.
Had MS so learned council for deputy sir. Is played for by MS so learned council for the petitioner. List this matter 4 weeks, awaiting service report.
MK Das for BTC Lordship.
MK Das, BTC,
BTC.
learned standing on BTC and
Spot number 1. Secondary.
D Hazari, I mean, standing council, secondary education. Are present, huh? Yes. D Musayar.
Obliged, Lordship.
Please, your lordship. Lordship, kindly peruse the last order dated 26/11/2025, lordship. Regarding the prayer for interim release of payment, lordship. Instructions is awaited, lordship. For the last 45 months, I have not been paid the salary, lordship. No interim order is operating there, lordship. I am praying for current salary till disposal of the petition, lordship.
No, this, at this stage, how can?
Lordship,
This is listed for what?
listed for orders, lordship, and consideration of the interim prayer, lordship.
Where it is?
Lordship, in the last paragraph of the order dated 26/11/2025, lordship.
Yes, who is that? Elementary education.
For the last 3.5 years, lordship, I am not paid the salary, lordship. And I am on the verge of retirement also, lordship. I am
Heard, Mr.
P board, lordship.
P. Bordoloi, London Council for the petitioner. List of non-appears for the respondents. List of this court while issuing notice on 26/11/2025 directed the London Standing Council for Elementary Education Department, Mr. M.S.N. Phukan, to obtain instruction as to why salary of the petitioner has not been released till that, huh? List of next para. Salary has not been released, released till that. List of. Since the Learned Standing Council, despite receipt of the acceptance of the notice, even after the acceptance of notice remains absent, Mr. Considering above, the interim order. Where it is? Where do you say the interim prayer will be considered?
Lordship, also issue notice on the interim prayer, lordship. That is there. Only interim prayer is for the current salary, lordship, not for the pending dues, lordship.
This court consider, in view of the above, this court would proceed to consider the interim prayer of the petitioner. Next prayer. Heard on interim prayer. it is projected that being agreed with the provincialization of the service of the petitioner. Who is the respondent number 5?
Respondent number 5 is a private respondent, Lordship. 3 and 4,
You just tell their name, I'm asking.
Lordship,
One Sri
Pramod Bora.
Pramod Bora has approached this court by a writ petition being WPC number 4246 of 2020, which was disposed of on 10/03/2023 by directing the respondent to you say Pramod Bora, respondent number 5 herein, huh? Then you write, huh? What I said? Huh. You first said one Sri Pramod Bora, comma, respondent number 5 herein, huh? Huh. Then, comma, has approached this court, huh? Approached this court. Being WPC 4246 of 2021, which was disposed of on 10/03/2023, huh? By directing the said respondent number 5. No, directing respondent to approach the tribunal along with the interim prayer for stay of the provincialization of the service of the petitioner. List of the respondent number 5 appears to have approached the tribunal in terms of the order of this court with a prayer for stay of the provincialization of the service of the petitioner, provincialization of the petitioner. Provincialization of the petitioner's service, however, it is, however, same appears to have been rejected. It is contended that the petitioner, the respondent authorities has not paid the current salary, paid the salary since 2000, since 22/03/2022. Therefore, it is submitted that the it is submitted that the respondent authorities may be directed to release the current salary pending disposal of this present petition. Next one. Having considered that the petitioner appears to be working as
tutor,
there being provincialization of his service and the salary has not been paid since 22/03/2022 without there being any impediments. I am of the considered view that the interim order is called for at this stage. Accordingly, it is directed at this stage. Interim order is called for at this stage. List of. Accordingly, it is directed that the respondent, the petitioner shall be paid with the current salary. List of. Learned Council is standing counsel for the Elementary Education Department to file their response by next.
Oblige, your Lord.
This after 4 weeks.
Oblige, your Lordship.
No, you just give this hearing. Continue, 42, 43, 44, 45. Yeah. Yes. yeah.
May I please, your lordship?
Yes.
Lordship, I am appearing on behalf of DCC Foucault.
Hmm.
And according to order 1911/2025, there is an order for steps upon respondent number 5.
Hmm.
And we have taken steps upon respondent number 5.
Third, MS Swenson Learning Council for the petition. Await service report. Upon respondent number 5. Yes, you are for?
Respondent 6, your lordship.
So who else?
Fine, for secondary.
MS so and so,
That is also secondary education.
secondary education, and MS
F. Hussain.
4,
Respondent
respondent are granted for the 3 weeks time to file affidavit.
We have filed, second.
You have filed?
Yes, yes.
In that case, are present. Are present. 14, 15. This 14, 15. Yes.
16. Of like.
May it please your lordship,
Yes, madam.
this petition for drawing a contempt proceeding is being filed for not complying with the order of this.
Here we are filing appeal lawsuit in this case. This order is not an implementable order lawsuit. Because we are filing an appeal lawsuit, let it come immediate after vacation lawsuit.
Lord, my lord,
Is there any stay?
No stay lawsuit. We are filing lawsuit. We're going to file.
Just-
We have already filed with by this lawsuit.
but I have no knowledge. My lord, I have a little submission, my lord.
Yes.
Order was passed on 7th of September 2023, my lord, directing to pay compensation of rupees 1 lakh within 2 months from the date of receipt of the certified copy. My lord, for 2 years, this matter is pending, my lord. And when the contempt petition was filed, they appeared on 2 occasions and they made a prayer that they need time to take instruction. And now they are saying that they are filing an appeal. We have no knowledge, my lord.
No, that will not be.
No knowledge. And secondly, my lord, this is a compensation matter because I was a petty chowkidar. I served in the school for long 13 years without a single farthing. My appointment was void because I was appointed by the authority who had no authority to appoint me. But considering the length of service, my dedication, this honorable court was pleased that as a vicarious liability, this government is liable. So I was given a consolation amount, rupees 1 lakh, and passed in the year 2023. 2 years have passed, and now they are coming that they are filing an appeal, my lord.
That is a difficult lawsuit. The school was provincialized school. He was appointed by the SMC, which has no authority.
Submitted, that I have submitted.
And moreover, lawsuit, this order was issued, that honorable court order was issued 7/12/23. That was submitted by the petitioner to the authority on 21/12/24 after 1 year lawsuit.
No. It's
Yes, that is
no.
record. We are filing appeal.
No, 9-1.
In that appeal lawsuit,
No.
we will submit
It's
everything.
absolutely wrong. 9-1. I have stated on affidavit. No, 9-1. It was submitted on 9-1, my lord. How my learned friend can make such assertion that copy is there, my lord? It was received by the office.
I have the instruction lawsuit where we are filing appeal in this case lawsuit.
False, my lord. My petition will show that it was received, the certified copy was received and it was immediately submitted on 9th of January. And from 9th of January, nearly 2 years have passed, and now they are saying that it was filed after 1 year. My lord, what a false and misleading statement my learned friend is making.
No, I am not making, it is my instruction this lawsuit.
Well, that
We are filing an appeal in this case also.
No, there is no such affidavit that it was filed. Your lordship will take note of that. They have not stated on affidavit. My petition stands
my lord. My submission stands.
He was appointed by the SMC
that is
lordship.
not merit.
So government is not responsible for that.
That is on merit, my lord. Because this honorable court, after considering the matter at length and after hearing both sides, my lord, was pleased to direct to pay compensation of rupees 1 lakh within 2 months from the date of receipt of the certified copy. Certified copy was filed on 9th of January 2024. Order was passed on 7th of.
Yes, I've understood. See, Mr. Sisti,
Yes, lordship.
just filing an FE
Yes.
will not absolve you from,
Yes, lordship. That is.
or you cannot say that you cannot.
Yes, yes, lordship.
So we're not concerned about whether you have filed appeal unless there is stay of the order.
Yes.
You have to comply.
Yes.
Now, if you say that if you want to file affidavit, we will
Ye-
grant some
Yes,
time.
we'll file
But-
affidavit in this case, lordship. Yes.
Then we'll
We'll
see.
file.
No,
Right.
it's no information, nothing, my lord.
No, we're not saying
Not in appeal, it is
whatever,
contempt.
we're not accepting or convince his submission that just because appeal has been filed, there's no order. But then if he says that whether this has been, it is implementable or not, an appeal is a ground for, non-compliance, we'll see, give them 2 weeks' time.
Yes, yes.
You
lordship.
file an
We'll file,
affidavit.
we'll file affidavit, lordship.
Let a date be fixed, my lord.
Huh?
A date may be fixed.
After 2 weeks, we'll see.
Then holiday will.
Our MS
what will happen.
B Chaudhary,
Yes,
learned
my lord.
counsel for the petitioner.
Naam
Uh,
dilo.
Considering that the petitioner is yet to comply with the order of this court, that is 07/2023, as prayed for by Mr. SMT Sisti, learned counsel for the alleged contender. List this matter after 2 weeks so as to enable Mr. Sisti to file affidavit.
Oblige, lordship. I'll file.
We'll see.
Yes,
after
I'll
2
file.
weeks. It's not a question of clarification. I'm just giving you a,
Yes, Yes,
window.
yes.
Ventilation to breed for 2 weeks.
May it please the lordship.
Huh? Yes.
Lordship, I'd like to pray for a little accommodation. Lordship, could it be taken up at 2?
2 o'clock. This a partner matter. Why 2 o'clock?
My senior has some difficulty in the first half, Lordship.
Why?
There's some difficulty, Lordship.
This court is also difficult at 2 o'clock. Then
Lordship, maybe after some time then.
where is? Huh?
He is coming.
After some time.
Wait, Lordship, my lord, though it's a very old matter, I paid for 2 weeks' time to find my Bakatma. Lord,
You have not filed.
yes, it's a earlier council has been a little bit bench. We need some time to file.
MS T. Wapangla. You have appeared last time.
My lord,
T.
please, I-
Wapangla learned counsel submits that she has been, she has obtained, she has been, she would like to file her power within 1 week.
Yes, my lord, I'm with you.
Mr. Therefore, phrase for listing of the matter after 2 weeks. MS A. Gyan, learned counsel for the learned CJC
Yes, ma'am.
is present. What is the matter?
My lord, this is
2014 matter.
2000, they have filed review petition, my lord, and review was allowed, then it's come, my lord, after.
Just after 3 weeks.
Item 22.
Please, your lordship.
Yes.
So I'll wait for some more time to, any other date, lordship. We'll
Why?
wait for the adjust.
Why?
Lordship, I could not complete the preparation, so SM to admit that, lordship, because it's too voluminous for me to suddenly get listed.
What is the matter?
It's regard to, they're claiming a post, promotional post
Financial upgradation.
Financial obligations to a next level post, Lordship.
2015.
Yes, Lordship. Lordship, any date Lordship will fix, will come back with the preparation. I'm apologetic with regard.
Or MS
P. Gupta.
P. Gupta, learned counsel for the petitioners, petitioner.
Petition.
I'm for the-
Mr.
Respondent number 5 and 6, Lordship.
Mr.
D Deca.
D.
D.
D. Deca, learned counsel for the petitioner. Respondent number
5 and 6, AIDC, Lordship.
5 and 6 AIDC. Submits that due to personal difficulty, he could not complete the preparation of the matter to address this court, therefore fresh for an accommodation. Mr. Considering about that this matter be listed after 3 weeks. Mr. However, considering that the matter is pending since 2015, the adjournment is granted as a last chance.
Yes, Lordship.
2015 matter.
Lordship, may I pray for a date?
Lordship. Even I'll pray for it.
Let's see, 3 weeks. You just give 3 weeks somewhere in Feb, isn't it?
Yes, Lordship, any date.
Any
Because
date?
January is not possible, even if it is listed. January in first week, February.
Highly obliged, Lordship.
The lordship, my lordship, I'm requesting for a passover as my senior is like hanging. in
Huh?
matter in other court. I'm seeking for a passover, my,
When?
at 2 p.m. today.
Not possible. On the prayer of MS?
Your lordship,
Huh? Your name, please.
El Tomar,
Appearing on behalf of Mr. Ardilal.
Yelal.
A. Lal, learned counsel for the petition, list this matter after 4 weeks as a last chance. As the matter is pending since 2016.
Obligement.
4 weeks. Yes.
My lord, matter relating to family pension, my lord.
Hmm.
During pendency, my lord, they have released provisional pension and thereafter regular pension was also granted by 17/4/2021. Case is pending for regarding interest part, my lord. Though they
Interest,
have,
you filed the, you approached the civil court.
no, my lord. This honorable court in various occasions, my lord, directed for interest, my lord. I have all the orders, my lord. And last occasion, they have asked for, directed the court for instructions, my lord, by order dated 28/8/2025 and thereafter on 16/9/25, 2 orders, my lord. And I have submitted copies also. Was directed and they have asked by whom the said interest was to be paid.
Where it is?
My lord, on 28/8/25, court has directed. And thereafter another order 16/9/25.
Yes, there's no talking, there's no question of, there's no mention of interest. It's only instruction.
Therefore, it is for interest, my lord.
Doesn't indicate, it doesn't reflect.
Maybe, my lord.
If it's not reflect, how can you say that on interest, the instruction?
Then, my lord,
Yes, what is your
what
interest?
videos will be same, my lord. What,
Huh?
what court's video, my lord.
Huh?
Honorable court's videos also there, my lord.
Video?
Recordings, my lord.
Are you saying that we are disbelieving you? Yes,
Lordship, there is no claim for interest in the writ petition, Lordship.
My lordship may kindly peruse my prayer.
And there is no specific prayer also, Lordship, from which date they want the interest, Lordship. Petitioner is claiming the interest.
Without coming before this court, they have not released my pension, my lord. Then they release provisional pension due to pendency of this petition.
Then,
Thereafter, they have, during pendency of the petition, they have finalized my pension. And I have received PPO number.
you have received everything.
No, only interest part is there, my.
Interest, how do we calculate? You have accepted that, you have
Per
to,
rule 197A, my.
huh?
Pension rules, there is a provision, my lord. 197A, a pension code from the Section 197A.
From which date to which date? Interest from which date?
My lord, I died, my husband died while in service, my lord. Died on 17/5/2021, my lord. Normally, my lord, pension was granted with effect from that date, my lord.
So it has been granted since that day.
My lord, it is up to this honorable court.
I'm asking, sir, why you are, appears to be little annoyed.
My lord, normally when pension was granted, interest should be there, my lord. calculated
When?
From that date.
From which date you have accepted?
Yes, ma'am.
That is, I'm asking,
Yes, ma'am.
you are saying something different.
Yes, madam, I have the PPO number. Madam. Madam, my PPO number, it was reflected, pension will be commenced from 18/05/2010.
69 is the rules in rules operating,
My lord,
rule 69. Is there any revised, I mean,
Na-
amended rule, new rule, pension rules?
regarding 197A, interest per.
Yes.
Yes, my lord, rule is there, interest on delayed payment of pension.
Sir, I'm asking, are you getting what I'm trying to ask you? Is the rule in vogue? 1969 is the rule in vogue, which is operating.
Yes, ma'am.
Is there any other rules, amended rules?
No, my lord, there is.
Is
no
there any amendment of this rule?
No, no amendment.
Are you sure?
As per my knowledge, there is no amendment, my lord.
Yes, madam. See, problem is simply claiming interest will not do.
My
Now you have accepted whatever during the pendency it has been paid. It has to be seen to pay interest. It has to be established. It is not due to the fault of the
Yes, ma'am.
claimant,
Yes, my lord.
maybe by fault of the department. That you have to establish. Then only interest can be directed. It's not simply asking that you should pay with interest. It's not done. Right? That is, first you have to establish. Show us anything that you have been paid. There is a delayed payment due to the fault.
Yes, my lord, they have paid provisional pension only, my lord, during pendency
See,
of this petition. my lord.
Certain things are like this. You are supposed to be paid within 1 month.
My lord.
There are certain official procedures who cannot be said to be, may not be said to be a fault of the department, or obviously may not be fault on your part, right? So unless you establish that there was a delay has caused due to the fault of the department or the authorities, it's not automatic. Automatic interest will be imposed.
My lord, they have filed their office base, my lord. My pension papers were not forwarded in due time, my lord. My husband died on 17/5/2010, my lord. Thereafter, I have filed this petition on 19/12/2017, my lord. Then provisional pension, only provisional pension was granted. But, that is also 2 years later, from 4/4/2019, my lord. And then, my lord, I have received pension
So
payment.
what is
order.
your calculation of interest? It's market value.
My
How
lord,
do you calculate?
My
How
lord,
much interest you will be entitled?
there are some judgments of this honorable court, my lord.
I'm asking why you are jumping to the judgment. I'm well conscious.
As per
I'm
bank,
aware of this.
as per bank interest.
I have
my lord.
indicated it's not simply, I mean, when you ask and it will be given. You will have to establish in each case that there was a delay. I mean, the fault lies or delay is on account of the fault of the respondents. So what I'm suggesting you is, it's up to you. Since you basically came before this court for non-payment of family pension, and in the meantime, during the pendency, everything has been granted, right? Right? Do you agree?
Not agree, my lord, because I have paid along with interest, my lord. My payer is specific, my lord.
Let me complete. You came before this court claiming payment of family pension, right? During the pendency, initially you had paid the provisional pension, then finally you have been granted, right? The essential, essentially your relief is granted. The remains the interest part. For interest, you will have to establish the delay is on account of the fault of the respondent, the state authorities. So I'm suggesting you withdraw this and file a proper petition showing how delay has been has occasioned, and it is on account of the fault of the respondents, right? We'll consider that.
My lord,
Because it's as per the rules which you have relied. I have seen the rule. It's not all, I mean, automatic. It's not been paid, now paid, you have to be with interest.
But they.
There must be
on
a
their affidavit-
default and fault on the part of the authority. You establish that. And basically that will be a jurisdiction who could be, they would lie before the appropriate civil court. But then, since the rule provides, and you could not show specifically that due to delay
I have.
on account of the
I have filed my
respondent,
reply in this case also.
reply is not been not.
They have filed affidavit, my lord. They have
Ah.
admitted, my lord, when my papers has been changed, my lord.
Hmm. Where it is? Where it is?
Wait, please, your lordship. Lordship, our affidavit filed on 21/12/2020, lordship. Lordship may see page number 3, lordship. Paragraph 4.
Hmm.
The husband of the petitioner, 6th line, lordship.
Hmm.
Paragraph 4, 6th line. The husband of the petitioner died on 17/5/2010. Due to non-receipt of legal heir certificate, the family pension paper of the petitioner could not be processed. In pursuance of the order dated 22/11/2018 passed by the Honorable Court, the petitioner has submitted the legal heir certificate issued by the Deputy Commissioner, West Karbi Anglong Hamren on 8/3/2019, lordship, which was received by the deponent on 3/4/2019, lordship. Thereafter, on receipt of next of kin certificate, the deponent sanctioned the provisional family pension by office order issued under so and so dated 4/4/2019. Lordship, directly after the family this thing certificate, next of kin certificate was submitted. Thereafter, the next day itself, the provisional family pension was issued, lordship.
So these are the things.
My lord,
Right.
but it is the duty of the, my lord, officers, my lord, for forwarding my pension papers, my lord. They are party here, my lord.
We have
At
for-
3
forwarded.
and 4, my lord, they respond, those respondents are parties here, my lord.
It's not a question of they being party, this is a question of whether the fault,
my lord,
fault
my
lies
pension-
with the authorities or
My
not.
pension papers will be forwarded by the authority.
It's not simple. Suppose if you have not furnished all these things, next to kin and all these were the requirements.
My lord,
You have
they
not furnished it.
never
The
asked-
moment they have received it, they have processed it.
At that time, they have never asked me for furnishing legal hair certificates, my lord.
But ultimately,
processing my-
ultimately you have submitted, isn't
Yes,
it?
my lord,
Did you submit it? Did you submit it?
I have submitted.
Then, so this, we will have to establish, it's not automatic. Just because there's a delay. I understand, it should be immediately. But certain procedures is required. So we just cannot fix up the whole thing.
Let them file affidavit, my lord,
What affidavit?
regarding interest. but
What interest? You have not said anything. That's why I'm suggesting you for the interest of your client, you file a better petition seeking this thing because you will be granting your liberty. On this, they have filed where is your statement with regard to Parapur? Your reply?
Yes, I have replied.
You have admitted this.
My legal hair certificate was issued on 8/3/2019, my lord.
Then
Thereafter, provisional pension was granted, my lord.
it's okay.
But, my lord, my pension papers is not forwarded, my lord, in due time, my lord.
Due time in the sense you have no, this, the legal was required. Right? You have admitting this. You have not said so anything. You have not said anything on. You are admitting this.
At
See,
first, my
therefore,
At
in my
first, my lord,
this
while
court's view,
proceeding-
by this documents, by this material,
yes,
you may not be entitled for.
but at first, my lord, while processing pension papers, my lord,
Mm,
the authority must to ask me, my lord, what documents I have to furnish, my lord.
mm.
In
When
court-
did you approach? when it was submitted? First, initially.
And AZ had not received all that documents, my lord, in due time, my lord.
Lordship, here AG is not the pension sanctioning authority, he is director of pensioning. Sanctioning authority.
So, director of pension not forwarded my documents at due time, my lord.
Ah,
It is,
Well, you have-
it is not my fault, my lord.
we say that it's your fault. I'm saying it, you have to show that it is the fault of the petitioner, there's a delayed payment. And you have admitted that it was a legal head survey or whatever is this, legal head survey issued on 2018.
My lord, I have other documents also, but they again asked me for legal hair documents, my lord.
Then you have
During,
submitted.
during processing pension protest, my lord, all columns were filled up, my lord.
Ah.
Name of the husband, name of the wife, name of the son,
Arre,
all are there.
sir, try
There
to
is specific
understand.
format.
Are you heck of argument are you making? I'm trying to work out the thing which may be beneficial to, I mean, just for the petitioner. Come up with clear statements and materials so that we can consider and grant a relief.
My lord, then matter may be fixed for hearing another date, my lord.
What hearing? Why?
I have to,
See, why I'm indicating there's no material is enough here to say, I mean, to grant you an interest.
my lord.
Because naturally, that point of time, you're only, essentially you want the family pension. Interest, though you have mentioned with interest, but interest was not in your mind at that point of time when this writ petition was filed.
Yes,
That is
my
what
lord.
I'm trying to indicate.
They have engaged me as an counsel, my lord, by approaching before this honorable court, my lord. Prior to that, the hard case was not considered.
I'm just trying to make you understand, right? Are you insisting that I should determine this on the materials available? Then I'll decide, no issue. I'm trying to indicate that come up with the better materials and pleadings so that we can properly determine and grant you relief. Reason is very simple. That point of time when this petition was filed, right? Normally we should not suggest because it's a family pension, widow. That's why I'm just indicating. Otherwise, it's not none of the business of the court to suggest that also. All right. I'll give you liberty to claim the interest with better particulars.
Lordship may kindly allow a date, my lord, for getting instructions from my client.
I'll decide. Dispose of.
My lord,
I've heard you enough.
and my lord, if lordship may deem fit, my lord, then liberty to file a fresh writ application. Better liberty to file a fresh.
That is, I'm trying to indicate you from since morning. Heard Mr. P. Bora.
D.
P. Bora, learned counsel for the petitioner. And Mr. A.M.S.
S. Temprai Lordship,
And
correspondent 4.
who else are there?
For 2 and 7.
The petitioner has filed this writ petition seeking payment of family pension,
My lord,
family pension on account of, in respect of her late husband,
my lord,
namely Sir Singh Engti, who died on 17/05/2010 while in service as grade 4 employee in Amri High School, Karbi Anglong, with interest. Christoph. To release the arrears as well as current family pension, as per ROP. That you write. Initially, but has filed this way so that for a direction to responded to release this so and so. That next, during the pendency of this writ petition, the petitioner has been granted initially the provisional and then
provisional family pension.
provision and then
From, by order dated 4/4/2019.
by order dated. Which order?
Inspector of Schools order, Karbi
By
Anglong.
order dated 20.
Passed by the inspection, inspector. of
By
Schools
order, by an order dated
4/4/2019.
4/4/2019. Thereafter,
A regular pension was
the
given
regular family pension
by order dated
by
17/4/2021.
an order, by an order dated 17/4/2021.
By the Director of Pension.
It is list of, thus essentially the prayer of the petitioner appears to have been, the grievance of the petitioner appears to have been redressed, except the claim of the claim for interest for delayed payment. Christoph. After hearing the learned counsel to the parties and perusal of the materials, no materials privacy indicates to show that the delayed payment of the family pension to the petitioner is clearly on account of the fault of the respondents, which warrants for payment of interest on delayed payment or on delayed
Provision 197A section.
list of the petitioner passed with under such circumstances, in such situation, the petitioner where dismissed, he may be allowed to withdraw this writ petition with a liberty to approach afresh with better particulars, claiming interest on the delayed payment of family pension. Mr. Considered above, the prayer for withdrawal is accepted. Mr. According with a liberty as prayed for, accordingly, writ petition stands closed with a liberty to the petitioner to approach afresh. approach afresh with better particulars as may be permissible under the law.
May I pray for indicating the rule, my lord, 190?
Obliged.
Yes.
You not only indicate, you bring every white, black and white on the next down.
Obliged, my lord.
We'll continue this. Huh? Yes, Pathar, right? Yes.
That is your lordship. Last occasion, while another friend was arguing on the point of maintainability, we completed our argument.
Hmm.
The other side was arguing on the point of maintainability of the petition.
Yes.
The last occasion, I think he will continue. Complete to press, yes, last occasion. I may give this short history, my lord. Acts, just to recollect. Here, this Pathar Parichalana Samiti before your lordship, whose lands have been affected, cultivable land have been affected by the old mining of the respondent, Coal India Limited. Entire lands have been degraded and rendered useless. And for that, earlier they approached this honorable court. This honorable court had issued directions to make assessment, inquiry in their presence. It was done. Finally, page 36, lordship may just see. An amount of rupees 2,98,000. 2,98,31,308 was directed to be paid by the page 38, 65, last but one para. It was by the additional district magistrate in Chukia. In the view of the above, I'm at page 65. When is 65? 65 because. Huh? But the internal page 38, my lord. In view of the above circumstances, the circle officer Margarita was directed to make final assessment as per government notified GIRAT rate prevailing before 1998 and again notified in the year 1988. But assessment of compensation of those 28 persons submitted by the appellant company should not be made for this period from 1989 to 1992. Accordingly, the circle officer Margarita made assessment of compensation for an amount of rupees 2,98,31,300 for damage of crops due to pollution caused by the appellant company from 1989 to 2006. To the respondents 1 and 2 society. That was the direction. And then it came before this honorable court again. And this honorable court, page 200 and page 39, 222. Another application number 4807 on 2008, page 39. Here, they approached this court again, and this court directed will read out from page 45, my lord. Paragraph 11. This honorable court's direction. Dated 2/9/2014. Paragraph 11. Merely because the coal company was not allowed to participate in the verification exercise, suffering of continued damage cannot be ruled out altogether.
Okay, sir.
Yes,
Understood.
that was the position.
Ultimately, you are seeking 2 crore 98 lakhs
Yes.
31 as per the verification
Yes,
decision of in the meeting
yes,
by the additional deputy commissioner.
right.
So they have said they refused to pay because it was not prepared during 93 to 95.
Right.
Page 60,
Page 60.
they are refusing it.
Yeah,
They said that number one, this assessment was not done
yes,
by not allowing them to participate, or it was not a joint verification. And the compensation is already paid during 1990. What is that? 1990?
93.
93 to 95. That is their stand. Yes. So you are arguing about the maintainability.
Maintaining.
yes,
Yes.
Your lordship.
because,
We'll finish it today
Yes, yes.
yes, yes,
within 15 minutes.
Sure. It won't take 10 minutes also.
You then 5 minutes. Sir, 5 minutes, please.
Your lordship may first. Paragraph 1 just later. Yeah. Lordship, please look into paragraph 1 of the petition. This is the case. That the petitioner is a society registered under the Societies Act under registration number so-and-so having its office at Lido, PS, Margarita, in Sukiasa. The petitioner society has paid an amount of ₹900 to the concerned authority for registration of the society, and the subdivisional agriculture officer, Margarita, issued a certificate under memo number so-and-so dated 25/3/2008 by certifying that Lido Sonali Pathar was registered in the Department of Agriculture, having registration number so-and-so. The specific case is that it is a society under the Registration of Societies Act. I'll just place section 6 of the Act. Your lordship has got the
Society's registration.
registration act, yes.
Yes.
Section 6. Rules by and against societies. Your lordship got it.
Yes.
Every society registered under this act may sue or be sued in the name of the president, chairman, or principal secretary or trustees, as shall be determined by the rules and regulations of the society. And in default of such determination, in the name of such person, as shall be appointed by the governing body for the occasion, provided that it shall be competent for any person having a claim or demand against the society to sue the president or chairman or principal secretary or the trustees thereof, if on application the governing body, some other officer or person be not nominated to be the defendant. This means clarified that if it is a society under the said act, the authorized person has to pursue a suit.
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 Not the writ petition.
No, writ petition also.
Where under the writ jurisdiction. We're exercising writ jurisdiction.
Writ jurisdiction, your
There's a, I don't have to point out,
Yes.
sir, there is a difference between suit and a writ petition.
True. Any case, I won't say suit.
It doesn't say.
Act may sue or be sued in the name of the president so and so.
Suits by and against the
Suing is-
society,
Even in a writ, it is suing.
subject to your, what is there in the law, we'll see. Prima facie, it's a suit applicable to the suit only. We are guided by the spirit of CPC, not by, and also our own rule, not strictly in the letter of the CPC. So it talks about the suits.
I will make this then.
What is that?
It is,
5 minutes is over.
no, yes,
You just read
this is in.
section 1 and 5 minutes over.
this is
Another
in-
5 minutes.
In case of,
Advocates Association.
it's Karnataka High Court, but it's about the writ petition.
Karnataka. Yes, which para?
Could have, judgment. Paragraph 15. Section 15 of the Karnataka Society Registration Act provides that every society registered under the Act may sue or be sued in the name of the president, chairman, or principal secretary, or the trustee, or shall be determined by the rules and regulations of the society.
It's
It-
Karnataka Societies Registration Act.
Is similar, you know. It really enables a registered society to determine by rules and regulations in whose name the society may sue or be sued. The rules and regulations may determine whether the society may sue may sue or be sued in the name of the president, chairman, principal secretary, or trustee. Where the rules and regulations do not so determine, it enables the governing council of the society, association, to appoint a person for the said purpose. In the absence of any such resolution by the association, enabling the secretary to initiate proceedings, I am of the considered view that present writ petition filed by the secretary representing the association is not maintainable. But here again, your Lordship. But however, insofar as the companion writ petition number so and so is concerned, the said writ petition will have to be taken note. Inasmuch as the said writ petition is filed by 2 members of the governing council, who have also questioned the order passed by the first respondent referring the elections which were to be held on 11/3/2006. The contentions urged by 3 senior counsel would also hold good in respect of the said writ petition. We are concerned here with writ petition, and this case deals directly with the writ petition. And the act is similar to the Societies Registration Act, which was adopted. The Supreme Court.
And in this case, nothing has been decided on the maintainability. It's para 15 is only reference to earlier case.
Earlier case, but.
But in this present case, nothing, I mean, in this case, nothing has been decided on maintainability.
No,
Except para 15, which has referred to earlier case, other case. Okay. Okay, sir, next.
the case was dismissed on that ground.
No, it's not on the ground.
This case is regarding a suit only, but I'll just point out. Supreme Court matter. E. Nazir versus Salafi Trust and Anna.
This pertains to suit.
True.
This is by whom?
2022 live law. Supreme Court, 334. Paragraph 15, you know, she will see. The aforesaid finding is completely contrary to law. A society registered under the Society Registration Act is entitled to sue and be sued only in terms of its bylaws. The bylaws may authorize the president or secretary or any other office bearer to institute or defend a suit for and on behalf of the society. Under Section 6 of the Society Registration Act, every society registered is, there's a quotation, even the Travancore Cochin Literary, Scientific and Charitable Societies Registration Act. Therefore, unless the plaintiff in a suit which claims to be a society demonstrates that it authorized by, that it is a registered entity and that the person who signed and verified the pleadings was authorized by the bylaws to do so, the suit cannot be entertained. The fact that the plaintiff in a suit happens to be a local unit or a Shakha unit of a registered society is of no consequence, unless the bylaws support the institution of such a suit. This was in relation to a Waqf case.
So far as suit is concerned, there may not be any dispute. So you just show us that
Now, he has not.
suits is akin to a writ petition. Suit includes the writ petition.
That case, your worship will go into the petition itself. They claim that it is a society, but
Where is the resolution?
there is no resolution.
No resolution,
No resolution.
no authorization.
No authorization and.
But
names
if
of the
if I correctly understood, I mean, what I indicated is that we're exercising writ jurisdiction.
True.
With
It
the
is a writ
suits, the
jurisdiction.
root, the writ petition can be strictly called a suit.
In my submission, your worship, it can be treated as a suit.
It has to be sure if you are not going on that. I'm just asking.
And that means
I don't know.
will, no, there is, I will clarify on that, your worship.
Huh?
I'll take some time in that case, on that point.
First clarify that, then we'll proceed.
In that case, your worship may grant me little time.
Hmm?
Your worship may grant me little time, I'll.
Yeah.
some time for that purpose. It's an important issue
Yes,
and there is law.
it's an important issue, but it's already decided. It is settled law.
That part whether it's settled or not is debatable. That's the reason I was.
It's not debatable. Either it may be considered a suit or it's not a suit at all.
And then whether the act contemplates only a suit and whether suit can be connected to a writ petition also. I will place my submissions.
When?
Give it a short date.
Now 20 minutes, you said for
A
10
short
minutes.
date.
You have not started as yet.
No, we are not gone into merits.
Marriage, no issue.
No,
Marriage, you have to pay.
no merits, your worship, whether I have to pay.
That's the reason you want to cut the route. Once the writ petition is not maintainable,
Your worship, it's an
no
admitted.
question of payment.
No, there's-
Merit, we have heard you.
your
And
worship, as far
it's,
as.
it's pursuant to the order of this court. It's been carried out.
No, it was not carried out. That's what.
I mean, there was a
Inquiry.
inquiry.
There's no inquiry.
No, inquiry.
They
in the sense-
admitted that they could not.
At
accept.
least there was a deliberation.
Deliberation
If
may
it
be,
cannot be verified again,
that is there, plus whatever,
physically,
what was verified.
then that's a deliberate.
Whatever was verified also was done.
Deliberation was done in
It
front
was
of, I mean,
in our- Against our.
including you.
No, no.
No, this deliberation, you
No,
have
it is
expressed that
wrong-
you
wrong-
cannot pay.
Wrongly stated there. There's, the records will show that we were not.
Have you
part.
challenged that?
We challenged it. We said.
Have you challenged?
Yes. we said
Where?
so. We challenged the order.
Yeah. Other writ petition.
Yes,
Other writ petition is by you.
yes.
Okay, sorry. Uh-huh.
The entire record will show right from the beginning without any verification notice, assessments were done.
Mm.
And those assessments also, your worship, are without any logic.
Ah.
On pure assumptions, amount was directed to be paid. Whether the bona fides of the petitioners have been ascertained. All these petitioners, there's some duplicate names and there's no list as to what, who they are, whether they are the owners of the lands they're claiming to be. There's
Acha,
no description of land is given.
93, 95, whom you have paid the compensation?
We paid to 29 people who were ascertained initially.
Huh?
There were 29. That was a list given by them.
It
on
was
that-
placed before before this court in the earlier round of writ
Yes,
petition.
yes. I've been there right through, right from 90.
Yes, so during this earlier round of litigations,
Yes.
before this court, it was taken note of, and finally it was a direction
The direction ultimately Lordship will see
for verification.
Justice H. Roy's judgment. He again directed.
Page 46.
Page 139 of our petition. Oh,
Page 45.
No, our
Writ petition. First writ petition, page 45. Para 11. Para 11. Page 45.
What has been stated here is, but merely because the coal company was not allowed to participate in the verification exercise, suffering of continued damage can't be ruled out. This is where. This is, last of the. If that be a possibility, and having regard to the orders passed by this court on 16/11/2006 in the writ petition number 4056 of 2003, which was left undisturbed by the division bench in the writ appeal number 58 of 2008, I am of the view that the district magistrate Tinsukia should be directed to decide whether any continuous damage was suffered in this case. But verification must be made through a participatory exercise where the coal company and the claimant society should be allowed to make their projections. When the extent of damage, if any, is finalized, the applicable rate of compensation must also be decided by taking into account the cutoff date as per the revised ZERAT list notified on 17/8/1998, or in other words, for the damage suffered prior to 17/8/98. The compensation should be made payable at the old rate, and for the post-88 damage payment should be made at the revised rate. That is talking about the rates.
Not 12, paragraph 12.
In paragraph 12, the matters are accordingly remitted back to the district magistrate Tinsukia to carry out a fresh exercise.
So please come to page 59, 1st June. The order which you have stated before that. There's a notice to General Mailers call India Margarita, serial number 2. And members present, page 60.
60 years.
A.K. Barali, GM, SP Datta,
Yes.
DGM, S.
We were there. We had appeared, but your lordship will see what is written.
Cannot be made of damage degradation as on
The
date
meeting
for the
was
period of
presided over-
1918-2006. It was also rated that
It
no
was informed
degradation.
in a meeting by the above officials that as per direction of Honorable Guwahati High Court dated 2/3/2015, joint field verification was conducted on 22nd and 23rd May 2015. It was observed that fresh assessment cannot be made of damage degradation as on date for the period of 89 to 2006. It was also reiterated that no degradation damages had further taken place after 2006. You will see from this that they purportedly held a joint verification which was not possible according to them. Then how could there be a verification?
Therefore, the earlier assessment was there.
So that was wrong. That was already decided by this honorable court.
Saying what?
Directing that you have a fresh assessment. So that.
Fresh assessment cannot
earlier
be done.
assessment- Earlier assessment was not agreed to by this honorable. That's why it was, the direction was given that fresh assessment be done. And that was done. The early assessment assessed the amount of 2.98 lakhs or only payable to members of Lido Sonali Pathargaon Parichalan Samiti is agreeable to the committee. That is their committee. Petitioner agreed. It has nothing to do with the getting money largest from the state. However, Coal India management did not agree to the proposal of payment of the above amount As the assessment was not prepared jointly and compensation was already paid during the period 93 to 95. That was originally in 95, proper application was made, it was considered and payment was directed, which we paid. Subsequently,
The year 2007.
either the family grew or some outsiders came, but they were not shown anywhere as members of the society. There is no record at all before your lordship to establish that these petitioners were actually bona fide members of that particular society. It is not relevant now, but whether the damage that was claimed by them was caused by the Coal India Limited or by the petitioners.
Or for some other company, but there's only minors.
Could have been some other parties also. We're not the only mining company there. And in any event, none of these petitioners are entitled to any benefit here because their identities are not known. The lands are not identified. And what kind of assessment could have been done on the basis of vague statements? My submission, your lordship, this matter requires to be dismissed on the ground of vagueness of the writ petition itself. There, Hmm? Basis for any assessment. On that basis, I now, this honorable court can also direct payment. There have been 7 rounds of litigation in this case.
9 and 10, it's not 9 and 10, 7 by
9 and 10 now, these ones. And Lordship, earlier PIL was filed, that was dismissed. Then they went to the Human Rights Commission, they also, it was dismissed. Then the Pollution Control Board, they also did. Then they approached this court.
Those are for different purposes.
No, they claiming compensation only.
Hmm? Pollution Control Board.
Yes, they went to all these authorities.
It's okay, that's not, may not be that relevant now. That's all.
The pollution is relevant because what was the claim for? Damages because of pollution caused to the lands. That is what they say. But if the Pollution Control Board itself says no, there's no pollution or damage.
No, it's not, that's why I'm saying it may not be relevant for the purpose of this matter.
Lordship, all through we've been going through this, it is continuous litigation going on. Names of petitioners change. Identity not established. Whether they are members of the society they represent, that is not given. No details at all. And Lordship, no, I leave it to your Lordship, may decide in their favor, I have no problem. But my submission
Obviously.
is- my submission is,
Why the court has to hear you? We'll hear and we'll decide.
Lordship, that is true. Because your Lordship is showing the
So it would
inclination.
not be appropriate to say that whatever way we decide, and how to decide, you cannot.
We are not dictating, we are,
Yes,
we are.
sir,
Your
we are
Lordship-
hearing, I
Your
am
Lordship
hearing,
indicated,
I am hearing you. Although you say 10 minutes, it's nearly 40 minutes. So still I am hearing you.
on the maintainability of the first petition.
Huh?
That was on maintainability of the first petition.
That too, it took another 20 minutes, 25 minutes. Anyway, yes, it's on there. That's not I'm saying. We're not stopping you from argument, but in certain cases,
Only,
it depends on case to case.
only thing, Your Lordship, this matter does not deserve to be entertained.
That I have heard you.
That is my submission.
Yes. Number one, it's not
Both are-
maintainable
Both on facts.
because of section 6 of Registration Act.
Yes.
There is no resolution of the society. Right? Number two, on merit, the decision, I mean, the minutes, the verification, decision,
Nothing was done.
there is no verification as such, although you were there.
I was there present in the meeting,
Hmm.
not in physical verification. Because there is no
No,
possibility.
there's a question of physics. They said it's not possible to assess now.
It cannot be held that we were present for that purpose.
You were present.
For verification, no, because there was no verification.
You have find your signature, you have put your signature. You have
In the
subscribed
meeting-
to it.
In the meeting, and then we refused to accept the assessment.
No, nobody is saying that there's a verification. After the verification only, there will be meeting only, whether it's possible or not.
So-called verification, which they themselves admit in that last page only.
So is it possible now to have a re-verification, fresh verification?
That also, but everything has to be ascertained. Nothing in details have been done.
No, now, is it possible according to you?
No.
Can there be any, I mean, if it's possible to have a
Because
fresh
After
verification?
2006, there was no pollution, so. No mining. No mining in that area also. We stopped mining in that location. Now, it is only a claim for that.
So you are not working now
Not in that.
in that area? Where you are working now?
It's a large area. Huge. It's a township now.
5,500.
Okay.
We work in patches, and this is one particular patch.
Then,
Commission, they have not established their own case regarding damages caused by Coal India and the area where it was damaged. Nothing-
damage in respect of the land or what? or the I mean, the environment?
It is crops.
Huh?
They say it is crops
Not the land,
because the land being polluted.
not the land. Is that the compensation is not for the land? Is it for the land?
No, the land is this.
Land and the damage of the land.
Land has not been identified and damage is for crops.
That's all, sir.
That's all. I have nothing more to add.
And your writ petition,
In my petition, I'm submitting from that. It should be allowed.
huh?
It should be allowed on the grounds of what I submitted regarding the lack of identity of the petitioners.
Writ
lack of-
petition of Mr. Mohanto will be dismissed,
Yes,
huh? Should be dismissed, and your writ petition should be allowed
allowed.
on the ground of maintainability in this. And so far
and
as your
other
writ
reasons.
petition is
And
concerned, it
They will
is,
not merit,
there is no verification,
no verification,
there is no damage, nothing,
no identification of.
no
the tenants
identification of the
And the
affected persons.
petitioners, as
Ah,
well as the petitioners.
ah.
And whether a finding has arrived at positivity that Coal India is responsible for whatever damages they claim they have incurred. That's my submission.
Let us pay. Question of maintainability.
Hmm.
It is too late on the part of the respondent, the petitioner in the other petition, to raise this issue. There were 3-4 occasions, litigations. And they never raised this issue. Rather, they made us as a party in the name of the society. And you see, in their writ petition, page 107, it is at no point of time they raised this issue earlier before this honorable court on 2-3 times there was litigation. This was the writ appeal 58 of 2008, first writ appeal.
Yep.
My learned friend was there.
Interview.
Annexure 10,
Huh?
105, writ appeal number 58.
एक मिनट में go करूँ?
Not अपना काम
No,
देखो.
ऐसा क्या था?
Yeah, now,
No, Your Lordship, one thing I may point out. Raising question of law can be done at any time.
I'm coming to it, my lord. Question of law, yes, but then at the earliest point of time, they
No,
must raise it.
No, Supreme Court
And
says.
otherwise also, this is
Supreme Court
not
says-
sustainable. I'm coming to it. Otherwise, this is not sustainable.
Name is not.
The Coal India filed this appeal, and at page 107, Lordship will file.
Hmm.
They made versus. This is Coal India was the appellant. Coal India, then number 2 was General Manager, Coal India Limited versus Mohanlal Bania, the person who was affected in person, they came and this person name is there. Then Lido, Somobai, Sonali Potter, Porisalana Soniki. And Mohanlal Bania was the secretary of the committee. They made it party and no point was raised that time. It was all decided. And this was decided, this writ appeal, what the honorable court said. Honorable court said that page 112 in their application itself. Appellate court's decision. Now we're going to go past that. Whether, Lordship got it at 112.
Hmm.
Whether compensation was paid to all the riots who suffered damage caused by the appellant company. That was established already. Court has held it like this, that all the riots who suffered damage caused by the appellant company or not is a question which cannot be determined on the basis of the limited materials available on record. This is regarding whether compensation was paid to all the riots or not. But damage was done and they suffered the damage that was already established. They never questioned it. Apart from the fact that এইটো কি লিখিছে? Assuming the সেইখন উলিওৱা। Apart from the fact that
Assuming in the
assuming in the year 1995, some of the victims were paid compensation for whatever damage found after examination under the head degradation. So land was degraded totally, that is why. It need not necessarily mean that the number of the riot who suffered the damage remains static for all the time to come. It all depends on various factors like the mining activity carried on by the appellant and various other factors. Another aspect of the matter is that the damage such as caused by the pollution created by the appellant company is a continued damage as it would affect the crops of the rice around the area each year. Therefore, the payment of compensation in 1 year, in our view, would not absolve the appellant company of its liabilities to compensate the riots who suffered the continued damage. Finding recorded, which was never assailed. In this circumstance, we do not see any reason to interfere with the order under appeal. However, the learned counsel for the appellant submitted that the above referred report of the Deputy Commissioner was prepared without any notice to the appellant. He therefore prayed that the appellants be permitted to file the objections, if any, to the report of the Deputy Commissioner before the Deputy Commissioner, and the Deputy Commissioner on receipt of such objections may consider the same and finalize the assessment of the compensation payable to the victims of the pollution. The learned counsel for the petitioner did not object to submission made by the learned counsel for the appellant. In these circumstances, we direct the appellants to file their objections, if any, to the report of the Deputy Commissioner referred to earlier within a period of 4 weeks from today, and on receipt of such objections, the Deputy Commissioner shall examine the same and make appropriate final assessment of the matter after affording all opportunity to the members of the Writ Petitioner Society. However, the whole exercise shall be completed within a period of 3 months from today, after making of the final report by the Deputy Commissioner in the light of the order passed today. The appellant company shall pay the compensation so determined to all those who are entitled under the report of the Deputy Commissioner. Kindly mark this part, my lord. Definite direction. It has never been assailed and it has never been diluted. So this remains, it holds the field now. They are duty bound and they now cannot argue that we are not bound to pay. And regarding other objections, I am coming. So this attain finally, the appellant company shall pay the compensation so determined to all those who are entitled under the report of the Deputy Commissioner. Thereafter, what happened? Thereafter, the success was taken up by the Deputy Commissioner. Their objections was taken. And in their application, it is 114. In my application, it is 36 page, 7th August 2008. They have noted. Lord, kindly see once Lordship is looking at my petition, my lord, or their petition.
Yes, same.
Yes, this is dated 7th August 2008. It refers to, let me read it out. In pursuance of the Honorable High Court's order dated 9/5/2008 in Writ Appeal 58, just has been read, my lord. By Northeastern Coalfields Coal India Limited, against the order dated 16/11/06 of the WPC so and so, the appellant filed their objection. Appellant filed their objection on 3608. On receipt of the objection, notices issued to both the parties for hearing on 26/7/608. On the date of hearing, that is on 27/6/08, Sri Mohari Lal Bonia, Secretary, Lidu Potter Panchayat Porichalona Samiti, the respondent number 1 filed a petition praying for copy of the objection filed by the appellant and also for allowing 10 days time for submission of written statement in reply to the objection of the appellant. Accordingly, the prayer was accepted and allowed to file written objection within 10 days. The appellant also produced the following documents. Exhibit 1 agreement, that is there. Exhibit 2, list of 139 persons with an amount of quantum of rate and date of payment. Exhibit 3, list of persons to propose to be awarded for compensation by the DC to 108 persons. Exhibit 4, certificates given by different villages including Sonali Pathar Porichalona Samiti, a comparative statement showing persons already given compensation but claiming again as per DC's award. So all those were there. Who are the persons who claim compensation? Now, kindly come down to the later part of page 36, that order, my lord, 7th August 2008. Last paragraph. The content of the objection, last paragraph, the content of the objection of appellant is that in pursuance of the ex parte order of the Honorable High Court dated 6/11/2006, whereby the Deputy Commissioner Tinsukia was directed to verify the claims of the petitioner society and its members and make an assessment to the damage caused to the opposition parties number 1 and 2, and also make an assessment of the payable to each one member on account of the damage. Accordingly, the DC made an assessment of the damages caused and assessed the compensation payable to the respondents number 1 and 2 amounting to rupees 4,61,48,840 only for the period of 1989 to 2006. The learned advocate for the appellant also submitted that they have already duly and finally compensated respondents 1 and some of the members of the respondent number 2 society in between 1991 to 1995, and they have given clear undertaking by executing an agreement stating that they will have no further claim against the degradation of their land in future. The learned advocate exhibited copy of agreements of compensation paid to 1 Sri so-and-so, place so-and-so, so-and-so, and 138 others, exhibit 1. They were represented by their counsel there, and also exhibited a comparative statement showing a name of persons already given compensation. The learned advocate further submitted that 28 persons who have already received compensation for the period with effect from 1989 to 1992 for damage of their crops due to pollution. Their names have again appeared in the compensation list prepared by the Deputy Commissioner for the same period and for the same land. The appellant company submitted a comparative statement showing name of persons already given compensation, but claiming again as per DC's order, exhibit 5. He further submitted that at that time, the value of compensation assessed by the circle officer Margarita at the rate of 1400 per bigha, and compensation was paid to them accordingly. Then how can the value of compensation be assessed at the rate of 3500 per bigha for the same period and the same plot of land? To raise this issue, they raised this issue. The learned advocate for the appellant also submitted that originally the number of cases of land degraded was 64 at the time of a joint survey carried out during 1993-94, and no further land have been found degraded. But the learned advocate for the appellant did not exhibit the list of such cases.
Okay, sir, I've read it.
Now, this is
It was challenged by them.
Yeah.
And there was a direction by on 0209/2014. It was
Yes.
taken to appeal. It was dismissed. Then verification was supposed to be done. There was a deliberation meeting,
they were given
but
notice.
then there was no verification as such,
Yes.
because this is not possible to assess.
Not
That's all. That's all.
So they were given, they were hard.
So that is what we are trying to say. So far as the maintainability is concerned, all along they didn't raise this. Therefore, at this
At this
point
stage,
of time,
at a time,
you
and
cannot raise this because you made the petitioner as a party
at a party.
and you have accepted, it was
Accepted,
taken
gone.
care all along in the litigation.
Exactly, Malad.
Cannot be made. Otherwise also, what do we say, so far as section 66 is concerned?
This is, Malad, it is a law which affects a suit. Suit cannot be equally placed with a writ petition. Suit, the meaning of the suit is something different. It has so many connotations. A suit, it follows the CPC. So according to CPC, a suit must be filed and proceeded and decided. Writ petition, CPC doesn't apply.
Why writ petitions, a suit, writ petition cannot be called suit?
Because, well, firstly, CPC doesn't apply in a writ petition. Writ petition is an
Why suit?
extraordinary jurisdiction.
Why suit doesn't include writ petition?
Because in my respectful submission, suit is an ordinary jurisdiction claim a certain right by an individual. But it is an extraordinary jurisdiction under 226 involving fundamental right and the violation of other rights. Therefore, CPC doesn't come in. It is an extraordinary provision given to the Constitutional Court to look into, and therefore a suit which is required to be filed by following certain process, specific procedure laid down under CPC by a plaintiff, conforming to all the requirements there. But the same is not applicable in writ petition. Writ petition, even a letter written to the honorable court is accepted as a writ petition and decided on the basis of whatever comes on affidavit before this honorable court. Therefore, it cannot be strictly construed that a suit will
Include the
a writ petition should also include a suit. A suit also include a writ petition. No, in my response, this will have serious repercussions. It will affect. It will not conform. Therefore, extraordinary power is given to this honorable court to see whether the bona fide claim has been raised or not. What are the rights affected? This is the requirement. Whether they were sleeping over their right or they have raised this in time. But CPC, Limitation Act, all these will come in. When cause of action arose, did you approach within time? Here, this is not strictly applicable. Therefore, it cannot, in my respectful submission, be said that suit includes a writ petition. It will not. You will never, and it was never held to be so. To my knowledge, I never found that it is held. A writ petition is equal to a suit. No, never.
So we'll continue at 2. Sir, this issue, whether the suit includes the writ petition, you can kindly have a look on this.
No, it is not.
It's according to this court, it is settled position. But I would like to hear from you, the seasoned senior lawyers. I would like to hear from seasoned senior lawyers.
Since they have raised this issue now.
My limited knowledge, I had my.
So as I have already submitted, I only agree that it cannot be.
I will continue at 2. Kindly look at.
Meanwhile, if I can get something, because
Kindly go through, I mean, look into it. We'll continue at 2.
yes,
I mean, on this issue.
Rest
Rest though, it's okay. Rest though, I've understood. And other day also you have argued.
yeah,
Only on this,
only at that point.
on this issue, kindly look into it during this thing.
But may not be possible, you should
Why?
look into the law.
Should I give you the law?
No, I'll find there is.
I mean, not, I'm just, on lighter note, I'm saying. Because it's a long pending matter, 2015, and it's a part hard with keeping it full. So what do you want?
Weeks time.
Tomorrow morning, Mala.
Because as of now, sir, to be frank, I'm not convinced. on maintainability. Therefore, I want to, I mean, since you have asked for some time, I just wanted to give only this, but we can try 1 hour, we can get it, whatever is there.
I don't have the facilities.
Not today, my learned friend says, tomorrow morning at 10:30, Lordship will take up.
Tomorrow it may not be possible.
Monday morning.
Not at 2, at 2
Monday
tomorrow.
Tuesday, your lordship, otherwise.
Monday or Tuesday.
Monday, Tuesday.
Motion day.
The only limited purpose. Will not hear more than, as I said, 10 minutes, but when the senior laws starts, it takes hours. But next day will not permit.
Now it has
Tuesday,
been thrust out. It is boiled down to the particular.
You don't
form.
have to, I mean, inferred, black and white. If it is includes, it's includes. If not includes, includes. And if there is no certain law, we'll lay down the law.
Exactly.
Tuesday.
Tuesday.
Tuesday. Tuesday, my lord. at
Because
five.
for me, I mean, I was expecting at 2 o'clock. Since he wants some more time.
Yeah.
Tuesday, then.
Right.
Tuesday or Wednesday, whatever.
Tuesday.
Tuesday.
Tuesday will be
Tuesday.
hearing day
Ah.
and
Next week, there's no hearing there.
I know
It's all motion. It's already notified. But then we'll take it up. We just want to finish it up.
What are
Maybe-
the of
maybe-
the list?
Therefore, if it can be taken up at 10:30 or at time may be indicated so that the matter can.
It's okay. You come, we'll see. Depends on the urgency. Suppose on Tuesday, so I couldn't say, it's since a motion day, there may be urgent matters, so we'll have to give preference. Since the matter is pending since 2015, why not another 1 day or 2?
Oh.
Tuesday, we
Tuesday.
cannot assure.
Worship.
Time, we cannot assure.
Okay.
As per the roster will, I mean, list will go. Heard Mr. K.K. Mohanta, learned senior counsel assisted by so and so, so and so. For WPC, 7170 of 2015, and Mr. MJ Ahmed, learned senior counsel assisted by
AM
Doctor.
M. Datta, learned counsel for petition and 2408 of 2016. List the matter on so and so, so and so. So as to the providing, so as to enable the learned senior counsel to address again on this to this enable the learned senior counsels to address on the point of whether the source includes the writ petition in reference to section 6 of Registration Act 18, Societies Registration Act 1860. On this point only.
Yes.
Peter remains part-heart, huh?
May I please allow? Also, may I please come to page 72. That's the interim order. also.
72.
Page 72, annex of 15. That's good. May I read now?
Yes, yes.
Let's say only first line, Lord.
Hmm.
In pursuance of the complaint received from the students of BRM Government College, Government Law College, and the subsequent visit of the Honorable Minister of Education, Government of Assam, to the college on 8/12/25, to assess the situation, the Honorable Minister directed that a team of officers from the Directorate of the Higher Education Assam be deputed to inquire into the matter and furnish an inquiry report immediately for the greater interest of the student community of the BRM Government Law College. Whether on 9/12/25, the inquiry team submitted its report. After careful examination of the inquiry report and all relevant documents, it has been found that the principal BRM Government Law College allows students to appear in the LLB semester examination despite their attendance being less than 70%. In some cases where attendance 50% or below, in gross violation of the Rule 12 of the Bar Council of India Rule so and so. Whereas, on the other hand, he has allowed certain numbers of students to appear in the examination despite their attendance being less than the stipulated norms. Now, lawsuit, the Rule 12 is quoted.
Your ground is that he's not, the director is not the appointing authority.
No, he,
Discipline
lordship, lordship, it is the lordship at page 73. Lordship, you can see that the,
As per notification.
yes, as per notification so and so. Lordship, may for my appointment order, lordship, may please come to Annexa 1, page 28. No way, I'm through a PSC lordship, I am not under that selection committee law. It is 28 Annexa 1, here, in subject to the receipt of satisfactory police vision report, the governor of Assam is pleased to appoint so and so. Is the governor of Assam lordship and the signature is of the commissioner and secretary of governor of Assam, government of Assam lordship. So my appointing authority is governor lordship and it is through my selection and everything is through a PSC.
It's not governor, it's a commissioner.
No, lordship, the commissioner, it's the, no, lordship, the governor of Assam is pleased and the commissioner is signed.
By virtue of Article 162.
No, lordship, the now commissioner, commissioner is my appointing authority.
Yes.
And lordship, the lordship can see in the, he has invoked this rule, lordship. And this rule, it is very clear, lordship. It is the appointing authority. The Assam Service Discipline and Appeal. Rules
Normally,
96.
otherwise also every rules should be appointing authority or discipline authority.
It is lordship, that's why I want to show lordship.
Yes.
At the 6th, lordship. He has invoked the 6(1)(a).
61A.
6(1)(a) at page 5, lordship. Oh, lordship, this book is different, lordship. So, lordship, it is the appointing authority. Lordship is very correct, lordship. It is the disciplinary or the appointing. The word is the appointing authority. It started like. And the proviso, lordship. Proviso, I am reading, lordship. Provided that where the order of suspension is made by an authority lower than the appointing authority.
This is what? This is a notification.
That is not it. Well, why you have given, I do not know.
Ah.
Lordship, this is the book, lordship, get the Rule 6, lordship.
Yes, yes.
Rule 6, the appointing authority or any authority who is the subordinate to so and so, and put the governor of Assam on the government of so and so.
Yes.
Then proviso, lordship. Provided that where the order of suspension is made by an authority lower than the appointing authority, such authority shall forthwith be reported appointing authority. There is no such stipulation in this order, lordship. Nothing.
No, it's okay. The appointing or any other authority which is subordinate to an other authority empowered by the governor.
Then proviso will apply, lordship. That is why I am reading proviso, lordship. Then the proviso will apply.
Monday, we'll see. You have been suspended. Monday or Tuesday, we'll take it up. You take instruction. See, admittedly, director is not the appointing authority. It's the commissioner secretary.
He knows, lordship.
Now the Rule 6 permits that to the subordinate to the appointing authority, provided it is empowered by the governor. I mean, he has to be empowered. Right?
Yes, madam.
And if it is in such situation, it has to be immediately report to the appointing authority.
And lordship, the 2B, lordship, 2B of that book, lordship. In our case, directly happened, 2B. Appointing authority in relation to the government servant, any particular means the authority empowered to appoint him to the post which he is holding at that time. At that time, lordship. 2B.
6(2)(b).
No, 2. Rule 2B, lordship. First page itself. Rule 2B.
Okay.
First page itself, Lordship.
In relation to government servant at any particular time, means the authority and power to appoint him to the post which he is holding.
So my appointment order is, Lordship, before page 28.
What is this? He has,
That is not required, Lordship. No, why?
no,
you-
he has
when I-
got this notification.
The notification is there.
Yeah, this has been quoted. Whereas as per notification.
Yes, yes.
Page
That that
70.
is why this notification, Lordship. I-
Yes,
This notification, Lordship. I have it.
yes.
This one.
Hmm? Yes, same.
Same, my lord.
28 May.
This,
Yes.
that notification, Lordship, two, itself came into force on the date of their publication in the official gazette.
Hmm.
This notification, Lordship, what he has realized.
Hmm.
And there is no retrospective, nothing, Lordship.
This of May, this was of May.
May 2025.
Has it been published in official gazette?
No, it's an official. It is there, Lordship. I have
It's
seen.
an official unit.
It is there, Lordship, in the official gazette.
As per 2A, my lord, appointing authority is the director of.
Where?
Now here,
2A, my lord.
two-way, yes. Nowadays, Lordship, it is directly.
So,
From down, no.
Before
From this date, Lordship. Not the earlier at that date, Lordship.
no, now,
No, now,
No,
my
they
appointing, he is not my appointment. Now, Lordship, the whole system is same.
suspension is of 9 December.
This is, Lordship, no, that is, Lordship, not under this, Lordship. My appointment is this.
Yes, that's I am understood.
Lordship, this is very clear, Lordship.
Yeah,
I
the
look at
relevant date it will be time, relevant time would be the date of suspension.
Yes, no, they're not the, on that day, Lordship. That is why on the suspension also it is very clearly written, Lordship. Here in this rule, Lordship, I will satisfy, Lordship. It said that on that day. Rule 2B, Lordship, may come.
Hmm.
2B,
Hmm.
appointing authority.
Yes, I've seen it.
In relation to government servant, in any particular means, authority empowered to appoint him to the post which he is holding at that time.
Obviously.
Now, Lordship, the official in the page 73, Lordship, of
Hmm.
my petition.
Hmm.
Now, therefore, at page 73,
Hmm.
what power he invoked, under what I have been suspended, Lordship.
Hmm.
Now, therefore, in view of the above circumstances, pending trial of the departmental proceeding in excess of power conferred under 6(1)(a) of the Assam Service Disciplinary Appeal Rules 1964. So I am covered on the. Lordship, then the 6(1)(a), Lordship, this is the proviso. Very clear, Lordship. No way this person can suspend him, Lordship. Lordship, to reach 6, proviso with 2B, Lordship. It's very clear, Lordship. And an extra one. Page 73, he has referred to this rule, Lordship, and he said the clause 31 of that rule. And this rule has no retrospective effect. I have seen line by line, Lordship. At least 6(1)(a), if he has suspended me, then Lordship, this rule has nothing to do.
We'll issue notice, sir. We'll see.
Lordship, the already the status quo be maintained, Lordship, otherwise it will.
That,
keep
that
going.
will be very good.
Status quo,
We'll
Lordship.
fix a date.
Yes,
We'll
Dating date, Lordship,
we'll
Lordship.
fix a short date. We'll
Yes.
consider your interim prayer.
And the-
Once it is
till the
suspended,
Status quo, Lordship.
it
No,
will
no,
be.
Lordship, otherwise there is no point, Lordship.
We'll
Otherwise,
consider.
Lordship, there's no point, Lordship.
No, we'll consider on next date.
No, no, Lordship,
Because
that-
I, prima facie,
till the status quo be maintained, Lordship.
in view of the rules, of course, it is only for appointment
Yes,
and condition of service.
yes,
But then obviously this will be applied. But once the power is conferred,
yes, it is there only.
as of now, I'm not saying that you are not
No,
correct.
Lordship, no, there's
So-
nothing, Lordship.
so-
Lordship,
So we'll consider your interim prayer. We'll sort that, we'll issue
no,
notice.
status quo be maintained, Lordship. It will be-
No, suspension,
Lordship, tomorrow-
once it
see,
is suspended,
Lordship.
you have
Lordship,
been, the department is contemplating a disciplinary proceedings.
Yes,
It will be very unfair to interfere at this stage. But then we'll consider on next
Lordship,
step.
Lordship, then better
Interim
to-
prayer will,
better to withdraw, Lordship. I'll talk to my client, Lordship, because otherwise there's no point, Lordship. Lordship will not give a status quo. Lordship, it is apparent, Lordship, that it is illegal. He
No.
has no power.
See-
Without power, Lordship, if someone can do something.
no,
Lordship,
that I've understood, but problem is that there's a rule, new rule who has
the
given
new
it power.
You not retrospective, Lordship.
Yes.
He is appointing authority.
No,
Now
see,
he will appoint, he will suspend.
No, that is suppose this the power to be exercised would be on the relevant date of suspension only.
Yes.
Not the date of will relate back to the appointment date.
No, no, Lordship, I have been suspended under this.
Yes.
Then Lordship, see, on that day, Lordship, please see 6(1).
Hmm.
First, Lordship, may please come to 2(b).
Yes, I've seen it.
Appointing authority in relation to a government servant at any particular time means the authority empowered to appoint him to the post which he is holding at that time.
Hmm.
At that time. That is my annexer A. That is my annexer A. And how can they will avert it by this? There is no overriding clause in this. Had there been an overriding clause, Lordship, then I agree.
Next week.
There is nothing.
In that case, next week we'll consider.
Next week, Lordship, till then be protected, Lordship. That is,
Next we'll consider your interim prayer.
no, Lordship,
Let me-
then I have to take instruction from my client to,
Ah.
Lordship. I'll inform you, Lordship, because otherwise there is no point. Lordship will protect me at least tomorrow or day after. Let them take the instruction anytime, Lordship, and then.
No, see, this has been immediate effect. It was passed on 9th.
No, I mean, sir, I have made a specific statement, Lordship, see,
Hmm.
in my petition, I have made a specific.
Okay, we'll
statement.
consider on Monday or Tuesday.
No,
Any day.
There is a provision for appeal also. Kindly have.
No, it's suspension. No, it's not. If it's prima facie, I mean, glaringly illegal.
Lordship, may please come to page 16.
Question.
Rule 14 says, my lord.
For what?
For appeal against order of suspension. If
Lordship.
Rule 14 of what?
this Assam Service Discipline and Appeal Rules, my lord, 1964. My lord, appeal against order of suspension. A government servant may appeal against an order of suspension of the authority to which the authority which made or is deemed to have made the order is immediately subordinate. Now, my lord, here here in this case, my lord,
suspension order was issued by director,
Then tomorrow,
and my lord, there are judgments also which says that
you ask this expect also, you
Tomorrow.
heard Mr. S. Sharma, another senior counsel assisted by Mr. Jayadeka, non-counsel for the petitioner. Challenge made in this writ petition is to the order dated 9/12/2025. Passed by the term whereby the petitioner is placed under suspension contemplating disciplinary proceedings. List of it is the contention of the petitioner and the contention of the learned senior counsel, Mr. Sharma, that the director secondary education, higher education, Assam has no authority as the appointing authority as provided under the rules of 1964. That rules, Assam discipline so and so. Is the commissioner and secretary to the Government of Assam Higher Education Department. List of referring to the clause 6, rule 6. Particularly the rule 6B. No, sorry. Referring to the various provisions of the rule 1964, particularly 2B within bracket small b, he submits that the appointing authority has clearly been defined and interpreted to mean an appointing authority in relation to a government servant at any point, any particular time, means the authority empowered to appoint him to the post which he is holding at that time. Please stop. The petitioner having been appointed by the Commissioner and Secretary to the Government of Assam Higher Education Department, in the garb of the power conferred under the Assam Government College notified on 28/05/2025, the director has no authority as the said rules of 2025 pertains to appointment and conditions, regulates the services of persons appointed to the Government College of Assam. The said rule is not retrospective in effect. Please stop. He submits that he contends that the impute order of suspension having been passed by the authority not competent under the rules is glaringly, palpably illegal. Therefore, seeks interference of this court. This stuff. Issue notice. Can we take it up tomorrow?
yes, madam. Otherwise,
No, we will not issue notice. We'll take it up tomorrow. You go look
Yes.
into it
Yes, sir.
with and obtain instruction.
Yes, sir, let him.
In case, I'll just indicate,
yes, madam.
if it is not, in any case, it appears that you cannot pass, you cannot be authorized under the rules of 2025 because the suspension
way.
is under
No way.
No, my lord,
64, right?
but that six, my lord, this appeal rules, my lord, B, at that time which my learned senior is referring, my lord, that time is, my lord,
No,
Not the past time, my lord.
we'll hear you.
yes, yes.
Hmm.
Tomorrow.
Mr. We'll issue notice, we'll not issue notice, we'll hear you tomorrow again.
Yes, yes.
Point three. We'll see tomorrow. Then if you think that this court is not inclined, you may withdraw also tomorrow, not today.
No, that's good. Tomorrow. No.
Mr. A.
As does, my lord.
S. Das, London
all the
Standing Council,
higher education.
Higher Education Department to obtain instruction as to whether the director has been conferred a power of appointing authority
Why I'm saying, Lordship,
under the rules, in terms of the rules of rules
rules of
1964, irrespective of the power conferred under rules, what's the rules?
25.
Assam Government College Service Rules 2025. Reason being, he has applied this, rule.
Yes, ma'am.
By virtue of this rule,
By
he has,
virtue of this
he has-
rule,
by this rule is substituting the Assam Government College Service Rule 2023. No way, Lordship, will come to my ear.
yes, we'll see tomorrow.
Because my appointment is under APSC, Lordship. No, and the, Lordship, in the meantime, no courtship, Lordship. No courtship. at least
Tomorrow,
one
sir,
night,
tomorrow, sir.
only one.
That's why I just wanted to be sure about all of us.
Lordship can see the first line. The minister visited the college, and what I am doing, Lordship, this court directed me to follow the rule. And I'm suffering.
It's a matter of 2 hours. We'll take it up tomorrow. We'll take it up tomorrow.
Because there is a high court
Listen-
order, Lordship. I
listen,
followed the high court order, so
Ah.
that is why I've been suspended.
Yeah, we'll see. If
I
required,
annexed that high court order.
I'll hear you a little more tomorrow. Little more tomorrow, if required.
Lordship is not issued.
List the
notice, you know.
matter, no,
Oh,
list the matter on
okay,
12th. We'll see.
thank you.
Hmm. Yes, sir.
May I please your lordship, my lord? Here in the instant case, my lord, say, very BTCS, my lord. নোটটো দিয়া লিস্ট অফ নোটটো দিয়া Well, I have prepared list of death pilot. My lord, before going to these things, my lord, you will
Who is for the respondent?
respondent one, BTC is not there, other are there, man. BTC is
Who is the main
Seven
respondent?
and eight.
Hmm?
is
Seven and eight and BTC and higher education.
You are.
No, I am for the universities, it is respondent number 7 and 8.
Who is the
And
main
one-
respondent?
And all are main respondent.
All are main.
All are main.
So, Mr. Chaudhary, if it is to be heard, they are to be there.
I'm
What to
starting-
do?
I'm-
Where are they?
BTC is not there, other are there, man. Oh.
Hmm. Huh?
Setting Council Pimantan Mukherjee, I'm a PhD. PhD.
Who, Musari?
See Mukherjee.
Where he is? What is the matter?
I'm coming, my lord.
It's a short matter or long matter?
It will take time, my lord. My matter is that, my lord. My humble submission before your lordship is that.
Well, ensure that next time all the respondents are present.
I give a message to the government. Yeah. The long
Okay.
pending matter. That
I
is-
understand, 2019.
Yes, my lord.
New Year,
But only
Let
that may
us
be- that may be fixed.
try your luck in the new year.
Yes, my lord. That may be fixed, my lord.
And Mr. NNB Chaudhary, Learned Counsel for the petitioner is present along with, who else are there?
KK Day, my lord.
KK Day and
Step. Your name?
no, KK Day and so and so. KK Day for
No, 7 and 8.
7 and 8. However, the Mr. So and so learned council, Musahari, BC Musahari, learned council, standing council, BTC, is not present, though represented by represented by MS A Parasar, learned council. In view of the above, let this matter be after when? First,
8 January, my lord.
it's not possible.
My lord.
We fixed so many matters. It would not be possible. After 25th. Since you are giving a fixed date,
My lord, can it be 29, my lord?
29. huh?
Yes, my lord. No,
Or
they are
20. As agreed to by so and so. huh?
This
This is what?
My lord, list of dates.
List of dates. You may take it back on next day because
Otherwise, my lord, I start the, my lord, letter and thereafter other side is not available.
this Guwahati has become a little chilled.
Yes, my lord.
It's little chilling.
Yes, my lord.
Okay. The earlier council has now been elevated to the bench, Lordship. Lordship may adjourn the matter so that we may file wakalat.
Wakalatnama. Mr.
K. Kolita, I am appearing on behalf of the D. Gogoi, Lordship.
K. Kolita, learned counsel, appearing on behalf of Mr. D. Gogoi, submitted. He would be filing the power on behalf of the power. Today you are filing or when? Within 1 week. Krishna. Therefore, friends for listing of the matter after 3 weeks. List after 3 weeks. Yes.
Hello.
Here, my lord, records were required, my lord, but we are seeking some more time, my lord, to produce the records.
The matter will be possible for the timing.
Record is required.
My lord.
Last occasion, R.R. Gogoi appeared on behalf of D. Gogoi. Record is required.
Required.
What is the issue?
Because they're challenging the findings of an inquiry report, my lord.
Suspended, dismissed.
Report, final order has not been given because there is a stay operating, my lord.
Acha. Okay. I had Mr. So-and-so learn counsel for the petitioner. Mr. I. Bortakut, learn standing counsel, Forest Department. Press for some time to bring, place the record, some time to obtain the records. List of considering that the matter pertains to considering that the challenge is to the inquiry report,
Inquiry report.
comma. Let this matter be listed after 3 weeks. So as to enable, no, please, Mr. Bortakut, standing counsel to produce the report on the next day. List accordingly.
Obliged.
In this case, kindly order dated, my lord, 25/3/2025, my lord. There was a direction to list this matter after the.
That has been disposed of now.
No, my lord.
No, 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 that,
No,
that
my
is
lord,
still pending, my lord.
What
Huh?
has happened, my lord? What has happened now in this matter?
Order dated?
What has happened in this?
Order of
25
what? 25/3/2025. Yes.
Yes. No, my lord, what has happened, your lordship would recall, day before yesterday, I made a mention before your lordship that the matter be tagged before or listed before the court of Honorable Mr. Justice UK Nair. The reason being, my lord, this appeal 417 of 2024 has been preferred against a judgment, my lord, rendered by Honorable Mr. Justice UK Nair in a matter which has been portrayed to be similar, but the matter is not similar. That was my prayer, my lord, that we could make a differentiation on facts. My senior is here, my lord. Sorry.
My lord, my submission before your lordship is that, my lord, the Honorable Justice Nair has said that let it be listed after the, my lord, disposal of the writ appeal. Now, the problem will be, my lord, the judgment of the Honorable Single Judge against which the writ appeal has been preferred, my lord, their facts are certainly, my lord, to some extent different. And my lord, very vital documents are not brought to the notice of the Honorable Single Judge when the, my lord, earlier petition was decided. Now, my lord, if we wait till the judgment delivered in the writ appeal, our points will not be, my lord, will not be able to, my lord, urge before the division bench. Now, in fact, my lord, my endeavor would be to satisfy your lordship that on facts and on law, my lord, since, my lord, certain documents were not placed and certain law was not placed before the Honorable Single Judge in the earlier writ petition, I would endeavor to, my lord, satisfy your lordship on that. In fact, my lord, Honorable Justice.
What is the case in that matter? This
This is-
8035.
8035.
Although, my lord,
8035.
there are two options, my lord, if I may, if I am correct, because, my lord, without hearing us and the documents that we have placed before this in our writ petition, if the writ appeal is decided, my lord, we will be highly prejudiced. So one option is that your lordship may say that this writ petition may be tagged with the writ appeal so that, my lord, we can also advance the argument there. Or, my lord, the second option is that your lordship will hear me and, my lord, then your lordship will decide whether, my lord, your lordship will take a different view in view of the, my lord, the documents that I'll place before lordship.
The finding of the honorable single judge was, well, with regard to the environment set that has been recorded in paragraph 8, my lord, that will be relevant. Based on that submission, my lord, the repetition was dismissed.
Your case has also been rejected.
No, my lord. In fact, the different in facts is that, my lord, so far as that particular reputation is concerned, my lord, there was an order of rejection, but in our case, my lord, we have been given the benefit of tutor. Instead of, my lord, assistant professor, we are now tutors at fixed pay of 30,000 rupees. And, my lord, the other difference is that, my lord, the most vital document, that is the fourth amendment of the regulation 2010, has not been, my lord, placed before the honorable single judge in that matter, my lord. That was very relevant, my lord. The question issue is actually, my lord, very small. There was a notification of 1/1/2011 by which, my lord, it was clarified that net slack and PhD will not be necessary. MPhil is enough for assistant professor. The issue that calls for consideration with your lordship is that, my lord, whether that notification of 1/11/2011 was valid till 22nd of March 2017. And I'd like to, my lord, to satisfy your lordship that it was valid, and therefore these persons were entitled to be assistant professors rather than, my lord, tutors. But in this case, that already decided case, he was not given any benefit, even tutorship was not given. And the 3-4, my lord, documents, if your lordship kindly peruse, your lordship will find that, my lord, there is a difference, and all the, my lord, matters were not produced before the honorable single judge in that matter.
So that case, he was not appointed at all.
Not appointed at all.
You are working as tutor. You wanted you should be appointed assistant professor. Same thing. No appointing, no appointing doesn't matter. Your grievance is that you are eligible to be appointed as assistant professor because this requirement of net and slate was relaxed
And that
at that point of time.
And that, my lord, that relaxation was valid till, my lord, 22nd of March 2000.
When you were considered.
My lord, in fact, the considerations were there, my lord, in 2014.
It has been rejected or what?
No, my lord, there has been nothing, no formal communication. But in 2017, my lord, when the colleges were provincialized, then, my lord, we were given, we were dropped. In 2013, my lord, when the college was provincialized, we were dropped. Thereafter, our cases were considered and no final decision has been taken. But in the affidavit, they say that we are not eligible. As per the 2017 Act. But then, my lord, the other issues which have been raised in my petition, they are not answered in the affidavit in opposition of the Director of Higher Education, and that is what I wanted to implore before.
No, you want that you should be provincialized under 2017 Act.
I should be provincialized, my lord, under the 2011 Act, because my lord, a valuable right has accrued to me. But for my lord not issuing the order, my lord, we had to approach this honorable court.
Otherwise also UGC norm requires the net and slate
No.
or the
No,
PhD.
EGC norm does not require, my lord. That is what, my lord, I wanted to show your lordship. There are other aspects, my lord. Whether UGC, my lord, the UGC regulations are entirely applicable to the state of Assam, or my lord, it will be applicable when it is adopted, and my lord, adoptions are only partial. That I'll show, my lord, I have annexed the documents in my affidavit to show that, my lord, government has given a stand that UGC regulations are not compulsory for the state of Assam unless it is adopted. These points were not raised before the, my lord, in the IBA case.
So in 2013, the 11 Act, you were eligible.
Yes, my lord.
It's gone now.
No, in fact, I want to, my lord, satisfy your lordship that till 2017, my lord, we are still eligible by virtue of the, my lord, notification of the state government.
Saying what? Saying what?
Saying that, my lord, that exemption still holds good up to 22nd of March 2017.
Why?
That is
How
what.
can they have this kind of?
Let us go through the document, my lord, if your lordship permits, my lord, I will satisfy your lordship on that. Next, let's say list of dates, my lord. List of.
My lord, before my senior Mr. my lord, if my lord is hearing this matter, my lord, then I have to seek some accommodation, my lord, for today. Because today, my lord, we are not ready.
Sir, we want to dismiss the writ petition.
I'm
I
sure,
have
my lord,
indicated that day to Mr. Sharma.
my lord, after hearing me, your lordship will not dismiss
Yes.
the writ petition, my lord.
After hearing, you will dismiss. So if he wants a time, what can I do?
Or
Maybe
perhaps-
you may have point, but then
But there is another option, my lord. I don't know what is, whether that is permissible, my lord. Since, my lord, these issues are not decided and these issues are not taken in the.
but it boils down to same issue.
No, can it be
ultimately.
taken, no, what I am submitting, can it be taken up that, my lord, without deciding, your lordship can refer the matter, my lord, tag it with the writ appeal, so that I can argue before the division.
No,
bench?
either will allow and will dismiss, then you may go to the appeal. In fact, this is fixed for dismissal today. I say it so.
No, it is not recorded, my lord.
It's recorded, not in here, it is recorded here. Anyway. Heard Mr. M.K. Chaudhary, learned senior counsel. Or this order is already been passed by, I don't know, which 25th March should be listed after the,
My lord, that will prejudice me, my lord. That's why I am, my lord, submitting before your lordship. Because, my lord, my point should not be considered before the division bench. And, my lord, the single.
no, you
bench-
have not objected to it also.
Now I am praying before your lordship.
You have not,
In fact, my lord, this was heard by Honorable Justice Nair and my lord, thereafter, my lord, after this order. then,
consideration in the present represent be deferred till the decision rendered with the said appeals. We'll have to modify this
That's right.
because you have accepted this.
No, in fact, my lord, thereafter also the matter was taken by Honorable Justice Nair and my lord, he said, try to satisfy me that I was wrong in the earlier case and that purport documents were not wrong. So, my lord, he was, he was, my lord, hearing the matter. In fact, he has heard the matter, although it is not part heard, my lord.
After passing of this order, I think, after passing of this order,
Think about it, we'll just adjourn it. There's a judicial order already. They do listed after, deferred after, till the decision is taken in the appeal.
No, your lordship will not say that, my lord. Your lordship will, since this order is already there, on their prayer, let it be adjourned for some time, my lord. Thereafter, in the meantime, my lord. we-
No, what I'm saying is that there's an order 25th 3. You have not objected to it and it was allowed. Therefore, we cannot just simply modify this.
Then, my lord, we will have.
So we'll just simply adjourn it. We'll not say anything today. On next date, we'll see. I think There should not be a bar to hear this matter by single bench. Heard Mr. M.K. Chaudhary, learned counsel for the, learned senior counsel assisted Mr. M. Sharma, learned counsel for the petitioners. All the huh? Then and so, and Ms. K.R. Padgiri. Then you write, huh? M.K. Chaudhary, learned senior assisted by so and Mr. Learned Counsel and Mr. K.R. Padgiri, learned counsel for the petitioners, huh? Mr. Chamwa, Chamwa.
University Grants.
University Johnson is present.
For the university.
What do you say? Have you gone through the earlier judgment?
We have filed our affidavit in Pen Kumar Sahab.
No, it's not on that. They, according to them, similar matter has been already decided by a coordinate bench, which is pending before the division bench.
That is
Is appeal.
my lord, is my lord senior
You go through this judgment and on next
month.
it may help. That senior counsel is saying that certain issues, I mean, certain documents was not placed, which is in their favor, and it's not exactly the similar. That is what he's trying to distinguish.
If you can distinguish, my lord, take up. Otherwise, after the.
No, that's what I'm saying. That's why I'm saying you go through his judgment. Huh? You furnish the copy. Mr.
Yes,
As the learned standing counsel. Hmm? Higher education. 6 for some accommodation today. Accordingly, please tell. Accordingly, let this matter be listed after 3 weeks. These matters, huh? List these matters.